What's up? What's up? How you doing? What's up? I know. It's just like this is me. This is me now. How's it going, guys? I am Lacey Jane. This is Criminally Confident, and it is Friday, January 2nd. So, if you're watching on replay, awesome. Still participate. Make sure to drop a comment. If you're watching live, what's up? I am so thankful that you have decided to watch us live and see how the rest of this debacle known as the Casey Anthony trial works out. We are going to be doing just a little bit of get ready with me. We are going to be talking all the things, engaging with the chat. It's a great place to hang out, just be cool. That's all we ask. And if you haven't done so already, please make sure to hit the thumbs up button on this video. Or if you're watching on your phone, I believe you can do it by double tapping the screen. That helps the algorithm. That is not for my own ego, I promise you. It helps get this in front of other people. If you could also make sure that you are subscribed to my channel, that would help me a whole lot. So 2026, let's not be petty. That should be like the theme of it, right? Let's go ahead and see what's going on in the chat. Hey, hi, maybe. What's up? Hi, Tamara. Good to see you. Oh, yeah. And I wanted to let you guys know that it is free to like my video and subscribe. I know it's a novel thought, but we're here. It's 2026. Let's go for it. Exciting thing happened to me today. Well, I guess like it probably happens for a lot of people, but uh I'm officially a part of the Amazon um associates program, which I don't know, maybe they let everyone in. I don't remember, but that's cool. It's cool as hell. Like I want to buy some stuff and share it with you guys and have you guys get it. Almost forgot to send you a link for tonight. It will be on its way shortly. If you guys haven't followed this dude, what are you doing? What are you doing? This is Shizzy. He's the man. Great dude. So please make sure to give him a follow. We love him here. And oh, thank you so much, maybe, for making sure to write that. If you are watching, this is so important. Meow, 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 meow. Like, focus on me. If you are watching on the horizontal screen, meaning if you are on a laptop or you are watching on your TV, I have just made this message pop up on your screens from Maybe Not. And that is a link that you can click so that you can be a part of the more engaged chat that we have going on the vertical screen, AKA if you are watching on your phone. That is the preferred method. We are eventually most likely going to move to just a vertical stream for analytical purposes only. But that is there for you if you are here to be a part of the chat. If not, I mean, don't worry about it, but just keep in mind we may be getting rid of the horizontal screen here as we continue to grow. And then I think like the last announcement I want to make is that things have been going wild and in a very good way for this channel. I don't know how else to say this. We have just blasted into the stratosphere in the last month. We went from having like a handful of viewers to last night I finished the stream at 55,000 views. That is like what? That is unheard of. I the only thing that I changed was, listening to what was going on around me, seeing an opportunity, and not being afraid to go for said opportunity. That's really all it comes down to. I saw, um I didn't see people doing anything like this, um, and I don't wanna share the other things. And that's it's worked with the algorithm. It's worked, and you guys are sharing, and you guys are caring and supporting, and it has, I normally have a very difficult December, and it was, like, I'm not gonna say it wasn't. I wasn't able to go see my father after 2 years, even though I was had my bags packed to leave that day. A lot of things. But you guys, I have just been able to refocus whatever sad feelings that I'm feeling, just, like, repurpose them into productivity with this channel, and it is completely I know it sounds crazy for me to say that it has changed my life, but it is gravely impacted my life in the best way possible. So, I am so thankful, and, despite what socialblade.com says, I am not making $1,000 a month. That would be great, but, that's not a real thing. Okay. Let's, go ahead. Yes, this is Shizzy's information. He's hilarious. If you're a pearl clutcher, he's probably not for you, because he'll get you. So, get over, some witnesses because it's I did the math, and I only have, like, um, a handful more streams with you before I, before some other stuff goes on that I'm not gonna be able to do 3-hour let me rewind. I am not going to be able to do 3 to 4-hour streams for 10 days in January. I'll leave it at that. Take whatever you will from that. Um, and I'm still going to be live streaming, and I'm going to be live streaming Tuesday through Friday during those hours, but it's not going to be, like we've been doing for the last month. Does that terrify me? Yes, but I have no option. So, we are going to pivot a little bit, and I ask for your grace during that time, but the end of January, we'll be right back to doing trials. And I will be covering a live trial happening here in Columbus, Ohio. So, ta-da! That's the news. You guys are all in the know now. And with that being said, getting back to my original point, I'm gonna have to pick and choose what we're listening to now, which is good. Like we're getting all the boring crap out of the way, and you guys are just getting like the action. Like yesterday, I couldn't believe yesterday. That was wild. I could not believe yesterday's stream. Like, what? So we're gonna pick up from there because I think that's the best plan of attack. Let me go ahead and share this. And make sure, once again, to please like and subscribe so we can get the algorithm out there. And here we go.
The defense has proposed Now, did Dr. Eichenblum provide a partial report?
No, Your Honor. He provided an affidavit, and he, in deposition, referred to it by that term as an affidavit. It does not. I provided the court with a copy of it the other day, and
well, this is what I'm looking at. It says affidavit R. Eichenblum dated January 21st, 2011. Is this what he provided?
yes, Your Honor, that's the item was provided
Okay.
to defense counsel.
This is the instruction I propose to give. All expert witnesses were required by order of the court to provide reports of their findings by providing 1, a complete statement of their opinions, 2, the reason for those opinions or conclusion, and 3, in a data or other information considered by the witness informing their opinion or conclusions. These reports were due at a time prior to the trial of this cause. The report of this witness was not provided to the state of Florida until Saturday, June 18th, 2011. You may consider this fact in judging the credibility of the witness's testimony. Mr. Baez?
Yes, sir. We maintain our objections since I have withdrawn the areas that were previously at issue. We just for the record.
Mr. Baez.
Okay. Before I do that, I need to have the witness come in, and I need to make an inquiry of the witness, and then I need, before I formally impose the sanction, I need to make a 3-pronged finding for purposes of the record. So let's have the witness come in. I have a few questions I need to ask him. I will file this first item is the defense's proposed instruction if I was going to give an instruction. The second item is the state's handwritten requested instruction.
You solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God.
I do.
My name is Richard Eichenboom.
Oh,
E-I-K-E-L-E-N-B-O-O-M. Eichenboom.
Doctor, I'm Belvin Perry. I'm the presiding judge in this case. When were you first retained by the defense?
The first investigation was, or first request, official request for the case was when we had to look over the evidence.
And when was that, sir?
That was on 13 July 2010. And of course, it was a couple of days before that.
July 2010.
Yes.
is anyone else having trouble hearing?
Sir, were
me?
you
It's
ever
been great
informed
for the
that
whole
you were
time.
required to produce a report outlining the opinions that you rendered in this case as a result of your examination of the evidence?
Except for the affidavit, I was not told that I had to render opinions or write another report.
Sir, were you ever informed of the following? Where expert witnesses have not prepared reports of examinations or tests, both the state and the defense are required to provide the following information, which shall be filed with the clerk of the court in form of a written pleading. 1, the expert's curriculum vitae or qualifications of the expert. 2, the expert's field of expertise or medical specialty. 3, a statement of the specific subjects upon which the expert will testify and offer opinions. 4, the substance of the facts which the expert is expected to testify. And 5, a summary of the expert's opinion and grounds for each opinion. Were you ever informed of that order of the court?
No, I don't recall that order.
Okay. I take it, sir, that you do not live in the continental United States?
Well, actually, since February, we're living in Conifer. But before that, we were living in the Netherlands.
Okay. How were you communicating with the defense? Was it by phone, email, or by what other means?
By phone, email, and Skype.
That's cute.
Were you ever requested or asked between December 2010 and May 1st of 2011 to reduce your opinions and findings in writing in a report format as I've just outlined?
Sorry, reduce? I mean, to write a report?
To write a report in the format that I've just outlined, sir.
No, I don't recall it.
Oh, shit.
Who was the principal person that you communicated with for the defense? Who were you getting your instructions from?
Mr. Baez.
Oh, my
we also had
God.
communication with Michelle.
No. Oh, no.
Now, from May of 2011 up until today's date, were you ever asked to reduce your report in the written format that I've just outlined, which would include all of your opinions that you were asked to produce?
Last Saturday, I talked with Mr. Baez, and then after the deposition, or after we went to the district attorney's office to do the deposition where we were refused, I was requested that I would write a report. So last Saturday night, we wrote a short report.
Between December 1st in the year 2010 up until May 1st, 2011, how many times have you communicated with members of the defense team?
Well, I'm not completely sure about that. I know we had communication short before we had to do the inspection of the evidence, and short after. And then for a long time, I didn't hear anything anymore. So we more or less lost contact and lost track of the case.
From December 1st, 2010 up until May 1st, 2011, were you readily available to be contacted by the defense team via email, telephone, or Skype?
Yes, the defense could reach us if they wanted. Yes.
You didn't disappear during that time
Well-
period, did you, sir?
No.
Okay. Either the state or the defense want to ask any questions along those lines that I've just asked.
Yes, sir.
You may proceed.
Mr. Eichenbohm, is this the first time anyone has ordered you to write a report on a case?
To write a report on a case?
Not on a case, on that had certain parameters like this one.
No, in the Dutch courts, yeah, you sometimes get a request, and that's by an investigative judge,
Baez.
and they can order you to investigate certain evidence or certain reports, or and write an opinion about these items.
And that would be based on things you've done, correct? Like run certain samples of DNA, inspected certain pieces of evidence.
Can be both. Can be on investigations which we have performed, but can also be on investigations of other laboratories, and then they want a second opinion about the methods used or conclusions drawn in those reports.
Okay. And the contact with your company back in January of 2011, that was done through your wife and Miss Medina, was it not?
Yes.
It wasn't
correct.
directly with you.
No.
Okay. And in fact, what occurred and how this order was, the information got back to you came originally from Miss Medina to your wife, and from your wife to you.
That's correct.
Objection assumes in fact not an evidence that the information of the order ever got to the witness. He's indicated it didn't.
I permit him to go ahead. Objection overruled.
Okay. Now, what you ended up doing is based on what your wife ended up telling you, correct?
Yes. You're talking about a very short affidavit.
Yes, the affidavit. Okay. And what you in turn ended up doing was filling out an affidavit of all the work that you had done up until this point, correct?
Yes, this is more or less about the evidence viewing.
Which was you wanted to inspect a piece of evidence for your own testing, but it was denied, correct? Yes. And then also that you had actually gone and done an inspection of the evidence, correct? And took photographs.
That's correct.
Okay. Were you ever told in any way, shape, or form to narrow your report or to exclude things from your report?
No.
Okay. And the report or affidavit that you ended up submitting was based on what you thought was required. of us.
Yes.
And you never spoke directly with Ms. Medina about what the court has actually ordered.
No,
That conversation actually took place with your wife and Ms. Medina, correct?
that's correct.
And then later on spoken to you, correct?
That's correct.
Do you recall exactly what your wife told you was required by the court? If you can remember.
No, I don't recall that.
Do you remember that conversation at all? Only that maybe it happened.
No, I don't remember the conversation at all. And the affidavit, I remember something about the affidavit, but we were very busy in the time. We were in the transfer time that we transferred from the Holland to the United States. So
Holland.
I didn't think much about this affidavit.
And the questions and the opinions that you raised and formulated on Saturday, they were first broached on Saturday, correct?
Yeah, when we were talking about the case in Saturday afternoon after the court session, then the idea came up to write a report or to form ideas about what topics we were talking about.
And these are not opinions that you held before and had discussed with us previously, and we determined that you were going to testify about these opinions prior to Saturday, and you just didn't not include them in your report, correct?
That's correct. On Friday, I made a PowerPoint presentation and just an average presentation for explaining contact DNA.
And Friday's PowerPoint presentation was just a general explanation of touch DNA and nothing more.
Yeah, and how PCR works.
They weren't specific as to any of the issues that were raised in this case, only an attempt to explain touch DNA.
Yes.
Okay. And upon our conversation on Saturday, you were then immediately asked if you would consider taking a deposition at the state attorney's office to now discuss these new opinions.
Yes. So during the lunch,
Yes.
we discussed the topics, and then about which I might be allowed to talk during court. And then we had an appointment with the district attorney's office to do deposit.
Okay. And what happened when you showed up at the state attorney's office?
We were refused entrance
By who?
by the district attorney.
Who? Is he sitting here?
I'll stipulate it was me.
Okay.
That'll help.
And what exactly did he say?
Bitch, it's me.
I don't recall exactly what he said, but as I understand it, I was at least not going to do a deposition.
Was he polite?
That sounded kind of rude.
Okay. And
Coming from
after that occurred, were you then instructed by Ms. Medina to immediately do a report?
Yes.
And you did that.
Yes,
And then you emailed that to me Saturday night.
that's correct.
Okay. I have no further questions.
Mr. Ashton, any questions?
May I just do it from here, John?
You may.
Is there any opinion that you have expressed in your Saturday afternoon report that you could not have developed 4 months ago through the same conversation with Mr. Bias?
Well, depends on the information which was available at that time, but like DNA reports, that probably could have been, if asked, I could have written a report about that.
Did he give you any new information during, and you spoke at lunch on Saturday,
Yes.
correct? Did he give you any new information during lunch on Saturday that you had not been provided with before?
Well, for me, it was new information because I didn't follow the case. So the case, when we left, we got a subpoena a week ago, or it's almost 2 weeks ago now. So the case for me was not really clear, and I know, of course, about the case, but I really didn't follow it. So for me, maybe the information was there, but for me, the information was not clear, and it was not clear which direction everything was going. So I needed that guidance during the lunch.
I understand you may have gotten new information about what Mr. Bias was interested in, but did he give you any new reports, any new factual information that you didn't have already?
I got, I think that was during Friday and Saturday. We got new information, so about crime scene pictures and some extra reports.
What new information?
Reports from the FBI and some extra pictures.
So you hadn't had the FBI reports before Friday?
Not all of them. No.
What new ones were you given? What new FBI reports were you given on Friday?
Oh, I just Actually, I got the whole folder. So
Well, can you give some any more guidance on what you had already and what you got that's new?
I've seen reports before. I think that was during the investigation of the evidence. So I form an opinion about the case, and I know something about what was already done.
Shout out to Wavy Talk.
And during
That's what I'm using.
last week, I requested for more information, digital, and I got all the reports, which were, again, that's a lot of reports, of course.
And you made that request after you got the subpoena and realized that they were actually going to let you testify.
Yes.
No further questions.
Okay. Pursuant to Richardson versus State 246 7 seconds 771, a 1971 decision of the Florida Supreme Court, as amplified in McDuffie versus State 977 second 312,
Hey, Nicole.
a 2007 decision of the Florida Supreme Court. The court will make the following finding of fact. 1, whether the discovery violation was willful or whether or not it was inadvertent. On December 10th, 2010, the court entered an order. The order was entitled Order Granting State's Motion for Clarification / to compel compliance with order for additional discovery. On December 1st, 2010, the state filed a motion to clarify. At a subsequent hearing, it was determined that there was some dispute concerning a prior order that the court had entered and the intent of certain language. The exact language of that court order at the time provided as follows. The defendant shall also provide to the state a list of the defendant's experts that shall include the subject matter as to what the expert would testify to and the area of expertise for each expert. The court goes on to say there was some debate about the word subject matter rather than substance. The court said, while the order included the term subject matter rather than substance, the court finds that the list provided by the defense does not comply with the intent of the order or the intent of the court as expressed in its November 29th, 2010 hearing. In order to clarify this issue, the court went on to order the following. Where experts have not prepared reports of examination or tests, both the state and the defense are required to provide the following information, which I have previously outlined. The court at that time thought that the matter was clear. In January, the court was back again to deal with this issue again. Going back to the December 10th order of 2010, the court specifically provided, with respect to all other experts, this information is to be provided by 3 p.m. on Thursday, December 23rd, 2010. There were some different deadlines with respect to Dr. Fairgrave and Dr. Bach. That information was to be provided by December 14th, 2010. Again, we had the same problem again, and the court again specified what information and reaffirmed its prior order and assessed sanctions. The obligation are for the attorneys to see that their witnesses comply with the orders of the courts. It is the attorney's job, be it the assistant state attorneys or defense counsel, to make sure that their expert witnesses comply with the order of the court. The court will find that this violation is not inadvertent, that it should have been clearly communicated to the expert, and that the expert should have been required to comply, and the expert was not. Therefore, the court finds that the discovery violation was willful and not inadvertent. The next issue is whether or not it was trivial or substantial. DNA even though the advent of DNA evidence has been around for a number of years, certain opinions that will be expressed by this witness as a result of the deposition, which is now on file, cannot be viewed as trivial when we start talking about rendering opinions with the of analyzing decomposition fluid in a trunk. So the court finds that it is not trivial but substantial. The next issue is whether or not it had a prejudicial effect on the opposing party in the preparation of their particular case. The court has delayed the testimony of this witness in order to give the state of Florida an opportunity to take this witness's deposition. If the witness had authored a report, put his opinions, the basis for his opinions, and the data which he relied upon with those opinions, then this court would not have given the state an opportunity to take his deposition because they chose not to do it. If those items would have been in his reports, then the state would not have had the opportunity. The question comes in as to whether or not I need to totally exclude his opinion about the possibility of a DNA analysis, which may have some Fry implications, and this court cannot, in this short period of time, make that particular determination. All of the cases indicate that the exclusion totally of testimony is an extreme remedy to be utilized in rare circumstances. The court has decided to do the following. At this juncture in time, the court will not permit the witness to testify
Oh my God.
on this particular issue dealing with
Oh my God.
the possibility of a DNA analysis on the decomposition of fluid in the trunk of the car. The court will give the defense until next week by Saturday to file whatever potential motion it wants to lay out for a Fry hearing. And the court then on Wednesday evening or Thursday evening at the conclusion of the day's testimony, after a 1 hour break to give the attorneys an opportunity to get something to eat, then we will come back and conduct whatever Fry hearing we would need to see whether or not this testimony does meet Fry, or whether or not there is even a Fry issue involved in that particular testimony. That should give each side ample opportunity to do what they need to do. And it is a remedy short of exclusion, but I will not permit this testimony at this particular time. Anything else on behalf of the defense or the state?
Not on this issue.
Okay.
I have a brief issue that I'd like to bring to the court's attention.
Yes, sir.
Today, we were handed by the state of Florida discovery, which included 2 compact discs.
Okay, we'll take that up at
Oh
noon
my God.
on your lunch hour.
Yes, sir.
But we got a jury that's sitting in there.
May I just make sure I'm clear?
Yes, sir. Yeah.
And I want to also make sure that he's removed from the PowerPoint any issue, anything related to the issue about DNA from decomp fluid needs to be removed from the PowerPoint.
I believe we're ready, Judge.
Okay. All right, let's return to jury.
Do you think that she, like, when she was hearing all this, she was like, You're fucking ruining.
Okay, Madam
my
Clerk, may
chance
you
to
swear the
freedom.
witness, please?
Swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God.
I do.
Okay, ladies and gentlemen of the jury, let me give you the following instructions. All expert witnesses were required by order of the court to provide reports of their findings by providing 1, a complete statement of their opinions, 2, the reasons for those opinions or conclusions, and 3, any data or other information considered by the witness informing their opinions or conclusions. These reports were due at a time prior to the trial of this cause. The report of this witness was not provided to the state of Florida until Saturday, June 18th, 2011. You may consider this fact in judging the credibility of the witness's testimony. You may proceed.
I please the court. Mr. Ashton. Good morning, ladies and gentlemen. Good morning, Mr. Eichenbohm.
Morning.
Actually, can you state your name for the record
Richard Eichenbohm.
and introduce yourself to the ladies and gentlemen of the jury? Sir, what is your profession?
I'm a DNA scientist.
Okay, and you have an accent. Where are you from?
Oh, I'm from the Netherlands, so I apologize for my accent.
Now, can you give the ladies and gentlemen of the jury a little bit of your educational background? Can you explain that to them?
Yes, I started working for the National Lab in the Netherlands, which is at that time was the only laboratory doing all the homicide and crime cases for the Netherlands in early 90s. And I started on the Department of Serology. The Department of Serology later became Department of Biology, because in the early 90s in the Netherlands, we also started with DNA. So I started on the serology department doing protein electrophoresis and blood group typing, which is the front runner for DNA. So later on, I became more involved in trace recovery, so finding the stains.
What does trace recovery mean?
Trace recovery, well, actually for the biology department, is finding all kinds of biological cell material, which could be used for either electrophoresis at the time in the beginning, and later on could be used for DNA profiling.
And have you had any other training on DNA?
Yeah, I went to laboratory school first. That was analytical chemistry, so that was not really in the field of biochemistry. And then during my working for the National Laboratory, I followed an education on biochemistry. Okay, and that means biochemistry. You work with DNA and you try to decipher DNA. So it's all involving decipher DNA. So it's all about DNA.
Okay. I'd like for you to speak as close to the microphone as possible so everyone can hear you a bit clearer. Now, how long have you been working as a DNA scientist?
Around 20 years now.
Okay. And how long did you work for, was it the Federal Police Department of the Netherlands, or?
No, the Netherlands Forensic Institute is under the Justice Department. Our system is a little bit different from the United States. So I was working for the Justice Department for around 13 years.
Okay. And after that, where did you work?
In 2005 or 2003, my wife started the company Independent Forensic Services, and I joined the company in 2005.
Were you ordered to do that?
No.
Okay. Now, sir, can you explain to the ladies and gentlemen of the jury what the difference is between regular DNA and low copy number DNA?
Objection, Your Honor. The witness is not qualified as yet, and I have one question.
Okay.
I'll pass over for qualification for the voir dire, and then I'll continue. Michael, take this. Let's go take it.
Mr. Eichenbohm, the highest degree that you have obtained is what's referred to as an engineer's degree in Holland. Is that correct?
That's correct.
And that engineer's degree is something between a bachelor's degree, but not quite up to a master's degree, somewhere in between those two, correct?
That's what you could say, yes.
Approximately. Your degree is in biochemistry, correct? And your specialization for your degree in biochemistry was in the study of luminol, correct?
That's correct.
That's a substance that is a that lights up to show where blood is, correct?
Yes, it reacts with oxidized metals.
Okay.
But it is used in CSI a lot for finding blood stains.
But you did not specialize in molecular biology or DNA in your biochemistry degree. That was not your area of specialization, correct?
That's not correct. Of course, the biochemistry education has biology, all kinds of fields and training in DNA and biochemistry. And then as a part of the last year where you do an internship, which of course was at my work, then I choose for a luminol subject. So that subject didn't contain much DNA. Of course, we were finding out, so actually it did contain quite a lot of DNA. What we tried to find is to make a new solution of luminol, which would not deteriorate DNA. So it had for sure something to do with DNA.
Now, when you were working at the same time you were in school, you were also working for the Netherlands Forensic Institute, Department of Biology. But you did not do DNA testing for that institution, did you?
I worked on the biology department, and the biology department is divided in sections. And during the time we're talking about my training, I became coordinator, and that means that you coordinate cases, you get all DNA results.
All right, that's
but it's all on paper, and I had to process the DNA cases, so that was during independent forensic services.
Correct. Prior to.
And they send out a sample or more samples, reference samples, and a crime sample, and then the laboratory has to perform DNA on that and then send back the results without knowing whether or not they were right. And after you send that in, a couple of months later, you get results back and you can see whether or not your test has been performed well according to 160 or more laboratories which were participating in that test. And till now, we always met the criteria of the other laboratories.
And have you, has your laboratory been contracted by law enforcement from your country to do DNA samples?
Yes.
How many times?
Over 100 times.
Okay. And in addition to that, have you ever been asked to testify as an expert witness in the area of DNA analysis?
That's correct.
How many times?
Over 70 times.
I'm sorry?
Over 70 times.
70 times. Okay. And to get this accreditation, are there any other requirements that they monitor your laboratory and its employees?
The training, it's about interpretation.
I would submit Mr. Eichenboom as an expert in DNA analysis.
Same objection.
Witness would be accepted as an expert witness in DNA analysis.
Judge, would this be a good time to break for lunch?
It would be a good time, Mr. Baez. Okay. Ladies and gentlemen, jury, we're going to recess for lunch. I'm going to ask that you return here at 1:30. Do not discuss this case among yourselves nor with anyone else. Thank you. Okay, Mr. Baez, you said you had another issue you wanted to raise?
Yes, sir.
Hello, Mike.
Sir, you may stand down. You can go to lunch. Be back by 1:25.
Sir, Judge.
Let's get the witness out. Make sure your staff tells him what time he needs to get back.
Do you guys notice that my Australian and UK accent are exactly the same? Because
You may proceed, Mr. Baez.
So, Your Honor, we were given this morning, which is the date, June 21st, 2011, some discovery that was provided to us by the state. In reviewing just a crude, rough peruse of what was given us, it appears that many of the documents that were turned over were items that have just recently come up and certainly beyond the state's control as to being able to turn the items over, with the exception of one compact disc. This has to deal with some material from the desktop computer from the Anthony home, specifically ones that were taken from June 16, 2008. This report was completed on April 26 of 2008, but yet not turned over to us for 2 months later, after the time that the state's experts have already testified, computer experts, that is, specifically. In reviewing this also, I also noticed some photographs that appear to be some internet searches for what would be considered, and this is just one example. It's not the brunt of our objection and issue, but it appears that there are photos of shot girls, which may have been at one time viewed on the Anthony home computer. I found this particularly interesting because during Mr. George's direct examination, he on multiple occasions referred to Miss Anthony organizing or trying to collect or give advice on the clothing that the shot girls should wear, which also leads me to believe that the state had prior notice of this discovery. And that's the point why I bring that up.
God, how many times all right.
the law enforcement had this computer since July 16th of 2008, going on 3 years now. And this report is now given to us subsequent to the state's experts already testifying. We would object to any presentation having to relate to these items. And I'm specifically referring to the computer items, not to what was disclosed previously, or what was disclosed of recent events that don't appear to be relevant to this case, unless of course they do become relevant at some time. But we would certainly object to that, and I guess I ask for a Richardson hearing on the matter, unless the state does not intend on using this newly found, well, not so newly found evidence.
Ms. Burdick?
Thank you, Your Honor. The first several items on the notice of discovery deal with a brief investigation that was conducted at the end of last week. Apparently, a citizen called the Orange County Sheriff's Office, left some information about an inmate who may have had contact with Ms. Anthony at a point in time when the inmate was in the Orange County Jail. That matter was investigated Thursday or Friday of last week. The report was generated. A statement was taken over the phone from this witness. That transcript was produced immediately. I received all of that information yesterday.
What was the name of the witness?
The name of the witness is April Whalen. Apparently, her child died in a swimming pool and was found by the child's grandfather, who immediately administered CPR and called 911. Ms. Whalen was in an adjacent cell to Ms. Anthony for a very brief period of time. Ms. Whalen indicates to law enforcement she did not talk to Casey Anthony. However, she doesn't remember if she talked to other inmates. So at the present time, it's being explored whether or not there was indirect contact. Be that as it may, as soon as I received the reports verifying that, in fact, Ms. Whalen's son did pass away in a drowning incident, as well as the reports from law enforcement of the follow-up on the information obtained by or delivered by a concerned citizen that was provided to Mr. Baez in the event that it does become relevant in relation to the subsequent investigation or the investigation that continues. The last item that is on the notice of discovery is simply a filtered copy of items from the hard drive that Mr. Baez has had for years. My use of these items, or our use of these items actually, would be exclusively in rebuttal if Ms. Anthony or another witness were to testify about specific activity occurring on June 16th. An examination of the hard drive indicates there was substantial computer activity that would rebut a lot of what Mr. Baez said in opening statement. Therefore, even though he had this information for years himself and had a computer, more than one computer consultant during the pendency of the case, as I recall, I decided that if we are going to use a demonstrative aid during the course of our rebuttal or even Ms. Anthony's cross-examination, that we would give that to counsel. And we have done so, rather than holding it for rebuttal.
Let me ask you these questions. I take it so we're all on the same page. This is contained in notice of provision of supplemental discovery dated June 21st, 2011, which bears your signature.
It does.
And items 1 through 6 all have to do with Miss April Whalen.
They do.
And that information was provided to you by law enforcement when?
The fact that they were conducting an investigation was communicated to me last Thursday or Friday, perhaps even Saturday. I believe they worked on this over the weekend. The written reports were delivered yesterday afternoon.
And so you delivered it as soon as you became aware of it and it was ready to be delivered.
That I did.
Okay. And the last item, item 7, is just a redacted version or demonstrative aid of an item that you had previously given to the defense.
The defense had their expert actually travel to the Orange County Sheriff's Office or provide a hard drive to the Orange County Sheriff's of the HP, the desktop computer in the Anthony home over 2 years ago. And the information contained on the hard drive is, of course, voluminous. I would have expected that counsel would have concentrated on the items on the computer on June 16th. However, since we did that and would like to use some of the items on the computer as a demonstrative aid, rather than having the sanction of exclusion that was suffered as a result of not providing a PowerPoint, I provided this information at this juncture.
Now, do you plan to utilize Ms. April Whalen?
Based on her statement, I would say no. However, as that information is investigated, there may be something from it that would be suitable for a rebuttal case. But at this juncture, as I've told Mr. Baez, that would be no. The court may not know. We continue to get phone call after email from concerned citizens, as I'm sure they do. We have to cull through that information to determine what are just fashion suggestions or prosecution suggestions and what is actual fact or Brady material. And we have been doing that on a regular basis. This was one of those items that was investigated. If it turns out to be something relevant at this juncture, I would say no, but it could before the end of the case.
Okay, as to items 1 through 6, Mr. Baez, any additional comments?
On those items, no.
Okay,
But I do have numerous comments on 7.
okay, let me finish 1 through 6.
But I have a list.
The
of
court will
reasons.
find that this is not a discovery violation. The court will specifically find that under Rule 3.220 of the Florida Rules of Criminal Procedure, that the state has a continuing duty to disclose information that becomes available to them. And also, under the case of Brady versus Maryland, they also have that duty, which they have complied with. Now, let's move to item number 7, Mr. Baez.
Yes, sir. If I understand Ms. Drainburdik's position, they gave us a copy of the hard drive, so therefore they gave us, this is a filtered version of that. And I would equate that to giving us 50 phone books and telling us pick out page
Specifically.
700,631.
You know, I understand this
the-
argument. I understand this argument. This is like hiding the lead, right? And I really don't think I understand why it's done. I understand that you don't want to hand feed your strategy to the opposing side. But at the same time, this is a woman's fucking life. And at the same time, you don't want to go to an appeal and have the Supreme Court and whoever is doing the appellate court look at this and be like, oh yeah, you were kind of douchey about this. Like, you shouldn't hand someone a huge hard drive and be like, okay, well, have fun. I don't know. I'm open to your guys' thoughts and opinions on that matter, but that's kind of always been my train of thought, and it drives me crazy that it happens.
Reports issued
I'm
by
just a
experts in
nice
this case.
gal.
And I guess we're going to get back to your order again. Issued certain opinions, laid out certain dates, laid out issues that may or may show up or may not. As it relates to this date, the only thing that was issued by an expert witness was Sandra Kahn's testimony or report that states the hours of inactivity for the times of the computer search, computer activity on that day. Not who was on, not who may or may not have been on the computer, who may or may not have been home, and what exactly, what pages came up, and so on and so forth. There's so much data that we could be referring to that it now appears
Thank you so
that
much, BP.
the state of Florida has decided to focus in on or use some evidence during their rebuttal case for which they had before the trial even started.
I don't show your responses because they're usually really long.
In addition to that, there's no way when we retain someone to verify the work of the prosecution in this case. So if they're going in a different direction and they issued other reports, especially given your honor's admonition and order, that's the area that we asked them to focus on, of course. And after determining that we would not be in need of a computer expert, we withdrew them from the witness list. So here we are without an expert witness on our case. They have had this information.
Just a second.
Bye.
Okay.
They've had this information for almost 3 years. And Ms. Drain Burdick's response is, we've had a copy of the hard drive, so therefore we've had the information. And that's not quite accurate, given the circumstances of how much data a computer contains.
I know you haven't had an opportunity to review it, but Ms. Burdick, what's on this disk for 61608?
Contains all of the computer activity on the desktop.
From what I can see, it's scribbly data. Some of them have photos.
Items created and accessed on the on the HP, the desktop on June 16th of 2008. Data that was available on the hard drive if they chose to filter it out themselves. Mr. Baez's opening statement focused on activity occurring in the morning hours of June 16th. The computer activity, as well as instant messages that were also sent in discovery years ago, negate that timeline.
Well, let me just simply ask this. Was information provided to the defense by the state of Florida on the computer activities on June 16th, 2008?
No, sir.
So you didn't get the hard drive?
We got the hard drive, but that's everything, Judge.
Well, but they gave you all of the information, correct?
They gave us a copy of the hard drive, which contains billions of pieces of data, and they issued reports of what opinions their experts were going to render and what information they had.
Well, let me ask you this, and
if I may clarify something else, Judge. And
I may piss
as it
you off
relates to
even more,
my opening
Judge.
statement, I specifically said the exact hour is unknown. So for the state to allege that this is information that would directly rebut that, again,
it would seem to me as an outsider looking in that
Pearl.
June 16, 2008 was the last time that the victim in this case was viewed by her grandparents. It became quite evident, even though it is not evidence, that from the opening statement of the defense, that the 16th was a day of great importance, and that a so-called timeline of activities dealing with Cindy Anthony as to how she spent her day on the 16th, Lee Anthony as to how he spent his day on the
Why
16th,
Lee? He doesn't live
George
with them.
Anthony on how he spent his day on the 16th, and last but not least, how Casey Anthony spent her day on the 16th, and whether or not what, if any, activities took place on the 16th of June, on the 15th of June, and on the 17th of June, both on 24-hour cycles, would have been at least of a minimum requirement of review. And I take it at some point, you did have a computer expert, I guess, regurgitate whatever was on that computer on some of those days.
yes, sir.
And if my memory serves me correctly, didn't the state's expert talk about various entries on the 16th when his testimony? He testified to certain events, didn't he?
He did not.
No, he did some event searches for chloroform and other things on other dates.
Correct.
But all of that information came off the hard drive.
It did.
Well,
Off the hard drive.
if the hard drive was provided to you, then it was left up to you to decide whether or not what searches you wanted to do on that hard drive.
Yeah, he's just.
And it was not denied access to the defense. And it was up to you to determine what days you chose to look at and what days you chose not to look at. And I'm trying to wonder, how could it be the fault of the state of Florida that you chose not to look at any particular date when you were given the entire hard drive, and you all knew what dates had some relevancy to this particular case.
I can tell you that we took your order to mean that all opinions that experts intend on rendering must be in a written report, and the basis for that opinion, all of this must be turned over to the defense.
Well, tell me what someone out of the state of the defense enlighten me as to what is the expert going to tell us other than extract, because most folks are not computer savvy. Some people are, some people are not, that can go in and tell us. All they're going to do is bring it up on the screen as to what activity occurred on that particular date.
I am not savvy.
Generally,
Savvy.
computer experts, when you want to render opinions, basically render opinions about whether or not somebody has tried to hide something or somebody has tried to doctor something. And, you know, that's what they generally do. But
can I add another point, Your Honor?
yes, sir.
Let me
Remember,
piss you off
y'all take as
more.
much time as you want to, because we're going to start back at 1:30.
Yes, sir. The issue here as well is we're giving computer information after the state has rested. We have withdrawn our computer experts from the witness list because we expected them to testify to what was in their reports and not to new evidence that was now given to us. So if the court's even considering this, allowing them to testify, we would certainly ask to have our experts, given the opportunity for our experts to review this material and see if at all it's.
They can look at it, but it's not new evidence. I don't know how something can be new evidence when it was given to you. Now, what you choose to do with it after you get it is your business, but it's not new evidence.
Business.
I disagree, but we can argue that issue at a later time, Judge.
Okay.
I would like more time to review the material, give it to our experts, and then
You are free to do that.
see if we have further points to make.
Okay. Anything else y'all would like to discuss?
Nothing further.
Okay. See you at 1:30.
All right. Give me a moment, children. Wilhelma Media.
Okay, you may be seated.
The hammer that brings the media.
Okay, let the record reflect that the defendant is present along with counsel for the defendant, assistant state attorneys.
Oh.
Both sides ready to proceed.
Yes, sir.
Let's return the witness.
While we're doing that, Judge, can I make a humble request?
Yes, sir.
I realize we have a short day tomorrow, but we would request that the court inform the jury that it is due to your honor schedule, not the defense. So
I
they
will
don't hold it against
happily.
us.
Did I tell them the reason why?
No, you didn't. No, you didn't, sir.
No, I would gladly do that.
Thank you, sir.
It also occurred to me that the court had discussed at some point saying something to the jury about witness Rodriguez and his not coming back. And I didn't know if you recalled that, but I think at some point we do.
At some point, we're going to need to do that. So y'all might want to consider crafting some language.
We have probably some further inquiry that we'd like to approach on that topic. We're discussing that
Okay.
as a team now. So
You want me to explain to them about the half a day when they come in now? Because I may forget later on.
Okay,
That's
I want to
Okay.
hear this. I was going to go to Spitz, but wait.
Let's return to jury. Okay, good afternoon, ladies and gentlemen of the jury. Did you heed all of my previous admonitions? Okay.
And does that-
Remember tomorrow, which is when.
Hey, maybe do you still have my link for Senegens? So what the products that I use on my entire face, I'm actually a distributor for, and I have been for 7 years. It is a company called Senegens, and it is known for its like 18 to 24 hours a day makeup products. So everything's made in America. It is non-comedogenic, so it doesn't get in your pores. It has sun protection in it and skincare products in the makeup. So you can use the other reason I love their products is because the versatility. I'm able to use the eye products as like a contour, as a highlight, as an eyeliner for my brows. Everything is very, very versatile in that way. And obviously it's great for weather if you live somewhere that's humid. If you are someone that gets watery eyes, it's all waterproof, smudge proof. Let me put it this way. It is 110 degrees in Jamaica in the month of September proof, as I got married there and my makeup stayed in place the whole time. So I have a 10% off promo code that maybe, oh, she doesn't have the link. Okay. So I will post the link for anyone that's interested. You can check out the website. All right. Let's go ahead and see what he says.
Wednesday, we will only work until noon or shortly thereafter. The reason for that is because I have a long-standing commitment for tomorrow at 1. And to give you a brief explanation, it deals with the state trial court's budget, which I serve on the executive committee of the Trial Court Budget Commission, which is having a meeting here. They have a meeting the next day, which I will miss. But that meeting is very important for the well-being of my circuit. That's where we discuss the distribution of funds for the next year. So I just want to make sure that we are represented when the bargaining begins. Okay. Mr. Byers, you may continue.
Thank you, Your Honor. May it please the court. Mr. Ashton. Good afternoon, ladies and gentlemen. Good afternoon, Mr. Eichenboom.
Hi.
Okay, we're going to talk about DNA. Now, sir, can you tell the ladies and gentlemen of the jury, give them an example of what touch DNA is?
Well, touch DNA
I guess
means you have all kinds of DNA. Now, everybody knows about blood, saliva, semen. Touch DNA is DNA which is transferred mainly through the hands. So I touch an object.
Werner, E-R-N-E-R, Spitz, S-P-I-T-Z.
You may proceed, Mr.
Good morning, Dr. Spitz. Could you tell us, sir, a little bit about just who you are? What is your profession, sir?
I'm a medical doctor, and I'm a forensic pathologist.
I know it may take a little while, but I do want to go through your academic training and background. Would you tell me, sir, where you went to medical school and when?
I went to medical school at the University of Geneva, Switzerland, School of Medicine from 1946 to 1950. And then I transferred
with Jesus himself
to the Hebrew University Hadassah Medical School in Jerusalem. At that time, it was before the State of Israel was established, so it was Palestine until 1948, and then from 1948 it became Israel. And I graduated from that university in 1953 and received my diploma to practice medicine.
Where did you do your internship, sir?
I did my internship at that same university where I graduated. And that internship was 1 year. And then after that year, I did a residency. And that residency was in pathology and lasted for another 5 years. And then during that time, I did a residency in pathology and forensic pathology. Pathology is what is practiced in a hospital where a physician examines tissues and body fluids to determine the nature of disease. And if a person dies, then pursuant to request of the next of kin, that same doctor can perform an autopsy. Usually in hospitals, when a person dies and an autopsy is performed, that autopsy is for educational purposes so that the doctors understand the mechanism of the disease, the condition that the person died from. Forensic pathology, on the other hand, is the science where a pathologist, he has to be a pathologist first. A pathologist will examine a body, usually, not always, but usually, do an autopsy pursuant to the state law. And he does not need a permission from the next of kin. and such a person will usually do an autopsy on what we call
Pure
police
class,
cases,
carrying around a
cases
big
which
plastic
are
bag makeup. I know.
suspicious, where somebody dies,
Behave yourself. I know.
where there is no medical doctor in attendance, where we don't know why that person died, and usually these are either accidents, suicides, homicides, or natural death.
Dr. Spitz, when did you have your first appointment in the world of academia? That is, as a faculty member. Do you remember?
Yes, I was appointed to let me say this, if I may, in 1959,
You can say whatever you want, honey bun.
I came to the United States. And as I came to the United States, I came I was paid by a grant from the University of Maryland, where I held an academic appointment and worked at the medical examiner's office for the state of Maryland in Baltimore.
That was in 1959?
That was in 1959.
Okay. Did you subsequently become a member of the faculty in Berlin?
In 1961, I think it was, I left this country and worked for 2 years and 3 months at the University Medical School of Berlin
working
in Germany.
in Israel beforehand.
And there I held an academic appointment too at the university.
Did you thereafter return to the University of Maryland?
Then after 2 years and 3 months, I returned to the United States, to Baltimore, to the medical examiner's office of the state of Maryland. And at that time, I held an academic appointment. In fact, I was associate professor at the Johns Hopkins University.
It's a great school.
And also at the University of Maryland.
Go Turtle.
Those basically during the same time, Johns Hopkins and University of Maryland?
I held 3 appointments. I was associate professor at the University of Maryland, and associate professor at Johns Hopkins University, and I was assistant medical examiner and later deputy chief medical examiner for the state of Maryland at the office of the chief medical examiner.
Are you presently associated as a professor within a university?
Yes. Then in 1972, I went to the medical examiner's office of Wayne County, which is in Michigan, in Detroit.
Hey,
and I was
Detroit,
appointed chief medical examiner there. In fact, that is why I went to Detroit. And also I was associate professor for a while, and then I was appointed to full professorship at the Wayne State University School of Medicine. I also held an appointment as adjunct professor of chemistry and taught toxicology at the University of Windsor in Windsor, Ontario, Canada, across the river from Detroit.
Are you still associated with the University of Windsor in Ontario, Canada?
Yes, I am, but only because I think by name or in name, because I have not taught there actually probably in the last 10 years.
Have you been, sir, the medical examiner or assistant medical examiner for the state of Maryland?
Yes, I was assistant medical examiner for the state of Maryland for approximately assistant and then deputy chief medical examiner, and the chief was quite sick, so I was quite active filling in for him for approximately 12 years.
Have you also been a chief medical examiner for Macomb County in Michigan?
Yes, I was. When I first came to Michigan as chief medical examiner for Wayne County, the county of Macomb, which is a little bit to the northeast of Detroit, asked me if I would do their autopsies for them. They had a chief medical examiner, but the chief medical examiner there was not a pathologist. So he needed a pathologist to tell him what people died from and what he thought was the manner of death, meaning homicide, suicide, natural causes, or accident. So they appointed me to do that work. But then that medical examiner died, and I became the chief medical examiner for Macomb County as well.
Are you a fellow in the College of American Pathologists, sir?
Yes.
Are you a fellow in the American Society of Clinical Pathologists?
Yes. These appointments now are emeritus appointments. That means I do not have to pay dues anymore.
Well, 4 years enough?
I'm sorry?
Never mind. Are you on the board of directors of the National Association of Medical Examiners?
I was. I'm not any longer. Yes.
Are you a fellow of the American Academy of Forensic Sciences?
Yes.
He didn't do George Floyd,
And
did he?
have you
Actually, I'm a fellow. A fellow is because I've been associated with the Society of Forensic Sciences for so long, I was appointed fellow, which is a higher level.
and have you served as vice president of the World Congress of Legal Medicine?
Yes, I still do.
Are you licensed to practice medicine in the member countries of the European Union?
Yes, in all the European countries that are members in the European Union. Yes, that's correct. But I'm also licensed in this country, in Michigan, in Virginia, in the District of Columbia, and in Maryland. District of Columbia meaning Washington, D.C.
Yes, sir. Thank you.
Have you received recognition and awards in connection with your professional work, sir?
I have received quite a number of awards, yes.
Okay.
I don't want to test your memory against mine, so I'll read and ask you some of them, okay?
Yes.
Did you attend and receive an award in recognition for the National Association of Medical Examiners back in 1972?
I probably would answer that
Hey,
by
Daniel.
saying to you that I really don't remember, but I probably did.
Okay. Have you received various awards from law enforcement communities and activities?
Yes, I did. These awards from law enforcement is because I received awards from local police. I received awards from the FBI. I received awards from all various types of law enforcement organizations, primarily because I give courses to them and I give lectures and serve as consultant to them when they ask me to interpret various cases.
Would that category include the New York State Police,
Yes,
Wayne County Medical Society,
yes.
Sterling Heights Citizens Police Academy,
Right. All
Yes.
right. Okay. All right.
American?
They're not all listed, so don't.
So
don't need to
you
make
are
an effort.
wasting your time.
Remember, peer-reviewed journals.
Okay.
And-
Cool.
Objection.
Ladies and gentlemen, the jury, Dr. Spitz will be accepted as an expert witness in the area of forensic pathology. You may proceed.
Do you remember, sir, when and how you first got involved or became involved with the case we're here for, State of Florida versus Casey Anthony?
Mascara going in the bra. We want to heat it up to body
I
temperature.
received a call, I think, from the Jose Baez law firm,
And what,
and I was asked to possibly, if I agreed to consult with the firm on this case, and also whether I have special requests that they would.
Your Honor, the object is hearsay and not responsive to the question of how you first contact.
I feel like it's a bad idea to be.
what was the
mean to
first thing that you
Mr.
did, sir, after speaking with the Baez law firm?
I requested to attend the postmortem examination because the postmortem examination at that time when I received that call had not been performed.
Meaning the autopsy by Dr. Garavaglia?
Yes, that's correct.
Did you request that you be allowed to be in attendance?
Objection, Your Honor. May we approach?
You may.
Ugh. I hate sidebars.
You may proceed.
I think the last question was, sir, did you request to attend the autopsy with Dr. Garavaglia?
Yes, I did.
Were you allowed to?
No, I was denied.
Trying to make it go.
Why did you want to?
Well, because first of all, it's useful to have seen the body in the condition that it was at that particular time, so that I have the same exposure to the body as the pathologist who is performing the autopsy in his or her official capacity. But in addition to that, there is an advantage in having two people of the same specialty look things over together, because
right.
4 eyes see more than 2 eyes, and I'm able to discuss the
Okay, imagine that you are that one lady, the pathologist who was on the stand that got really mad at Jose, and you get a call from the GOAT, the LeBron James of forensic pathology, and he wants to sit in on the most important autopsy you are ever going to perform in your professional career. Ye I can imagine that would be a little concerning. A little.
The findings on and in the body at the time that the body is there in front of us. This is custom in forensic pathology. It is custom in pathology. It is custom that even in a hospital setting, pathologists will send specimens from patients to other pathologists to see if...
Excuse me, sir. Objection, Your Honor. Not responsive to the question and relevance of the habits of medical pathologists.
Overruled.
It is customary that pathologists will send specimens from patients, dead or alive, to other pathologists across the country, sometimes across the world, to see if they concur or if they have ideas about this condition or that condition, because those ideas feature in the treatment that is afforded such patients, may be life-saving. In a dead person, there is no life-saving, but there is a question of what else can be done to make a reasonable diagnosis that conforms to all the facts of the case. And that was denied. So
Thereafter, sir,
Well, there we go.
did you conduct a second autopsy?
I did. When the official autopsy was terminated, I was given access to the remains, and I conducted such autopsy at the Bryant Funeral Home and cremation service, or I don't know, it's got a longer name, located in Orlando, and I was able to perform that autopsy at that place.
If you recall, sir, had Dr. Garavaglia completed her report of autopsy before you conducted the second one?
I don't really recall. I don't think so, that she had completed. I don't think she had completed her report.
When you conducted the autopsy, what, if any, first observations did you make that were remarkable to you?
Well, I came here to Orlando, equipped with all kinds of
Nice.
equipment to perform
Holy crap.
in
He died last year. Or in 2024. He died in April of 2024. And he lived in Michigan, and he died from a brief illness. He was included on the autopsies, or he consulted on the cases, rather, of JFK, MLK, OJ, and John Bonet. I feel like the Wikipedia person was just like trying to rap or something. I don't know. All right, we get it.
an autopsy, but I did not bring a saw because I was absolutely certain that this autopsy had been completely done. But when I came and I looked at the body, it had not been completely done.
What had not been done, sir, that you believe should have been done?
Well, it's not that I should believe, but I think the profession dictates that when an autopsy is done and done the way it should be done, there should be an examination of the interior of the head, and that was not done because the skull had not been opened.
And did you, sir, open the skull and examine it as a forensic pathologist?
I did.
May I approach the witness, Your Honor?
You may.
He was 97 years old.
Did you open the bag and take the contents out, sir?
I'm sorry, I couldn't hear.
Open the bag and take the contents out. And for the record, describe what you have there, sir.
This is a skull, not the skull of this deceased. This is a skull of an adult human being, not a plastic or fake material. This is bone. And I brought this because I thought it necessary that the trier of fact observe
Your Honor,
what...
not responsive and narrative and not relevant.
Sustain. Let's get a question.
Doctor, would you demonstrate, sir, what you mean by opening the skull, the protocol that you say Dr. Garavella did not do?
When a skull is opened, it is opened like I'm opening the skull now. So in other words, a saw is used to saw the skull all the way around and to remove the cap, as it is called, and look at the interior of the skull like I'm showing here and like I'm showing here. This is the outside, this is the inside.
And at the autopsy,
The outside, this is the inside.
Dr. Spitz, during the autopsy, were photographs taken, sir?
I'm sorry?
Did you take photographs?
I did. I did.
May I approach the lecture?
You may.
Show you what has been marked as the Fitz Exhibit BY for identification.
Yes.
Does that photograph fairly accurately portray the appearance of the skull after opened by you for the second autopsy?
Yes, it was. It is. I'm sorry. It is.
Please like my stream. Please. Please. Hey, what's up? I see you there. Shaking that ass. Please like the stream. Please subscribe. Don't be a douche in 2026. It's like the rule. Thanks, guys.
Opposition evidence. Yes. Thanks, Your Honor. I'll give you a copy of it.
Okay.
It will be received in evidence as defense exhibit numbered.
26.
We live.
With the court's permission, we have a,
It's okay. I mean it.
photograph that is marked as it's an AEC publicist.
You may.
And with the court's permission, may I have Dr. Spitz step down?
Yeah, but make sure we put a microphone on it.
For me?
For both of you.
All right.
Doctor, you may step down, sir.
Thank you, Your Honor.
Has that been done? We don't go forward.
I'm sorry.
Okay. All right, ma'am. Are those
Mr. Mason, can you switch places?
camera
He'll be over there.
snaps that we're
Oh, I'm
hearing?
sorry.
That would be better if he stands over there.
Over this edge?
Yeah,
Okay.
thank you.
I'll stand behind you. I think they can hear me. I don't know. Dr. Spitz, is that the enlargement?
Mr. Mason, I can't see. If you.
Oh, I can't say.
I'm trying to get this.
I know, but he has to be able to communicate with his witness, so
Oh,
go ahead.
Thank you, sir. This photograph enlarged here is the enlargement of the one that you took during the autopsy.
Yes.
Would you tell the court and the ladies and gentlemen of the jury what, if anything, is remarkable about the contents of the photograph that we have before them?
Well, this is what it represents the base of the skull, the bottom of this box. The lid is here, taken off by sawing all the way around. This is what you then would see if you look into the box. And this is where the vertebral column, the spine connects, and the spinal cord goes in here and into the brain. And this is the front. This is the back. Actually, it should be reversed. Do you want to do it with me?
Do it the right way.
Well,
I got it.
yeah, this is it.
Okay.
So this is the front, This is the back. This is the right side. This is the left side. And this is the reverse. That means this is the left side, because if you flip it over, then this part would go onto here. And what you see here is in this area, which is the left side of the skull, the base of the skull, you see black flecks. These black flecks are material which represent the last and permanent result of decomposition. What that means is that the brain, which fills this entire space, is gone. The brain has dissolved, but some parts like iron, magnesium, phosphate, sodium, chloride, all kinds of elements like that remain permanently. They don't disappear. This is ashes to ashes and dust to dust that you read in the Bible. And this is the dust which is remaining. And this amount of dust would have been probably just less than an ounce. But of course here, there is no 1 ounce, because some of this dust has been removed, has gone, I don't know, lost. And could have been, there could have been water, there could have been whatever, anyway, it's lost. These specks are attached to, they came down and they just remained. And they indicate the position of this skull over the decomposition process. Decomposition process takes time, quite a lot of time, to end up in just this, representing the specks, to be left over after the entire brain has gone. So this indicates the brain has disappeared, and those elements sunk by gravity to that place. And very little by little by little, over months, this has occurred. And it tells you the position of the skull.
What was the position of the skull?
The skull was positioned in a left side of the skull down. That means if this is the ground, the skull would have been something like this.
Show the jury with our friend here, sir, the position it would have been throughout the decomposition.
Well, here is the base of the skull. This and that are the same. And the specks are localized in this area on the left side. And the skull would have been like this, positioned like this. This would have been the position of the skull. Maybe with the face a little bit up, because it seems to be somewhat more to the back. So maybe a little bit like this.
All right, thank you, sir. If you can return up there. Has the jury had enough time to look at this? Dr. Spitz, did you review the records and documents contained in Dr. Garavalia's report of autopsy?
I did.
What, if any, problems did you detect?
Well, I'm sorry.
Yeah. What, if any, problems did you detect, sir, or deficiencies in her report?
Objection to the question of relevancy of deficiencies in reports that weren't testified to in this case in our issue.
I examined the entire skeleton. There was very little, if anything, any bones missing. And if there were, there would be little bones little parts, but most by far of the skeleton was available to be examined. The skull had not been opened, so I opened it and I showed the jury what I saw, what I found. There are certain things I did not find, which could have been there, but I did not find that they were. Like, for instance, some discoloration of certain parts of the skull, like the place where the ear is, the mechanism of the ear, the little protrusion of bone in back of the lower jaw, to the side here, on the side of the skull, and the mechanism of the ear, which is at the base, which is inside here and there. There could have been some discoloration, which I did not see. There were no fractures, no blows that I could identify on the skull. The skull was intact, in other words, undamaged. There was some damage to some bones, some long bones, meaning arms and legs, and other longer bones, which was due to post-mortem, meaning after death, predation by animals, meaning where animals find bones with some flesh on them and they go ahead and chew on those parts. That I found, but other than that, there was no damage. There was an area of one of the longer bones of the thigh, because the thigh is a long, fairly long bone in a child, 3 years old, probably around 5 inches maybe, and that had been opened by those who did the first autopsy. I surmised that they would do. When I saw that had been opened, I thought, well, they probably opened it in order to take specimens from the bone marrow.
Let me object to the narrative. I think we've gone away from the question that was answered.
I thought that they had done this, opened the bone to get access to the bone marrow. To the bone marrow cavity for the purpose of removing certain material that would be helpful in diagnosis. But I subsequently learned that had not been the case. So based on this examination, the cause of death remained unknown for those who did the first autopsy, and for me to some extent as well.
You recall reading Dr. Garavalia's statement references to duct tape?
I understand that there were some sections of duct tape on the lower face that were loosely on the face, but since there was, I should say, there was not a shred, I've not said that before, not a shred of soft tissue, no skin, no muscle, no fat, no nerves, no blood vessels, no nothing. So much so that when I came to Orlando to handle this, I brought a whole bunch of gloves, I bought an apron, I bought to protect myself from possible contamination. I used nothing because the skeleton that I received was in this condition. And like I touch this now without gloves, without apron, that's how I touched the other one. This is totally clean, and there's no bacteria, no nothing to contaminate me from handling this, just as little as there was to be contaminated, to be infected, or to not allowing me to handle those remains of this 3-year-old child. Consequently, I did not need any of the material that I brought. The tape was not there when I got the remains. The tape on pictures shows being to the side of the lower face, somewhere here on the left side, on the right side, if I remember correctly, hanging.
The photographs speak for themselves. The jury has seen them. You can interpret them for themselves.
Overruled.
Hanging on hair and hanging on roots of vegetation of the area that had, in the period where this was sort of in an excavated, in a little lower, partially under the surface of the ground. Vegetation had grown into this material. Plants benefit from the minerals and chemistry that is generated by decomposition.
Dr. Spitz, in the report from Dr. Gavalia, she indicated that the duct tape was clearly placed prior to decomposition. What, if any, opinion do you have regarding that assertion, sir?
Well, I have some problem with that, because when duct tape is applied to the skin and the skin decomposes, the duct tape just doesn't go anywhere. The duct tape just doesn't do anything. The duct tape becomes loose on the skeletal structure, in this case the face. The only thing that held the duct tape there was the roots and the hair that originally.
Always warm up mascara.
I don't
putting it
know
in
in
your
what
bra
fashion the
to get
duct
the
tape
body
came in contact
temperature.
with this.
It
There
applies
was
so much
no
better.
there was no there was nothing on the bone that would suggest duct tape. There was nothing on the duct tape that would suggest the application on the skin either. So I have some difficulty with identifying when this duct tape was placed, other than to say that it is my strong feeling and opinion that this duct tape was perhaps placed there to hold the lower jaw in place, because if the head is subjected to as complete a decomposition as it did, where there is absolutely no trace of flesh on this head or in this head, if I would have picked this up like this, the lower jaw would have dropped, just like I'm going to show you right now. Because this lower jaw is attached by, this would be like this. That's how, well, or like that. I would touch this to remove it and note what happens. The lower jaw falls down. So
I remember mentioning that.
being that it fell down,
early
if
on.
the duct tape was attached to the skull, it would have been held somewhat by the roots and maybe by the fact that there was hair between the duct tape and the lower jaw.
And sir, would you have expected there to be DNA on the duct tape if in fact it had been placed over the face?
I would have expected DNA, yes.
And would that be true whether it was placed?
I mean, if this was the duct tape was attached to the face, there would have been DNA from the face on the duct tape. I put duct tape on my arm, and when I removed it, I pulled out hair, sometimes with roots, from my arm on the duct tape.
And based on the...
And there's no doubt in my mind that if you would have had duct tape on the skin, there would have been some evidence of the presence of that skin DNA on that duct tape.
And
for the simple reason that there is a firm connection between the duct tape and the skin, to the point where decomposition is always less in an area of pressure against something, against a wall, against pieces of clothing that are tight. The decomposition is less in those areas where there's no air coming in, because bacteria also need to live, and bacteria are what cause decomposition.
All right. And then is it your opinion, sir, that the tape was not put on the face before decomposition, even antemortem?
No, it was not. I think that the duct tape was a later event, not an early event.
After decomposition?
After decomposition.
Major development.
Tell the ladies and gentlemen of the jury what the term adipocyte means.
Adipocyte is a stage in decomposition when the tissue becomes broken down, slimy, smelly.
I meant to show you guys.
You'll have to excuse me the comparison, but that is the comparison we pathologists use to compare. We are not always very elegant in our descriptions. We call it soapy. It's like soap. It's like soap. Adipocere is like soap. It is a special, especially fat undergoes adipocere. That is like soap, broken down to a consistency that is similar to wet soap.
Do you have an opinion, sir, as to how long it takes for adipocere to develop?
Adipocere develops at...
And we approach.
You may,
Wait, why would they object to that?
you may proceed.
You ruling? The question to you, sir, was how long does it take for adipocere to develop?
Adipocere under
I do.
optimal conditions.
And it's very
that
important.
means under conditions of warm environment will begin to develop such that we can call it adipocere within like 10 or 12 days.
Did you find, sir, the apparent presence of any adipocere?
Oh, no, absolutely not. There was, like I said, there is no more soft tissue on that skull like on this skull, compared to this skull.
Based on your review of Dr. Gavalier's report, folks, hold on a second. You reviewed the whole thing.
I'm sorry?
You reviewed all of Dr. Gavalier's report,
Yes,
including the toxicology report
including the toxicology,
and anthropology reports.
anthropology report.
Were you able to determine, sir, if there is any evidence as to the cause of death in this case?
Well, there are, you can rule out certain causes of death, but you cannot answer the definitive question of what this person, this child, really died from. She could have died of certain conditions that at this point we don't see. But you cannot rule out all conditions, but you can rule out some. You could, for example, rule out that there was a skull fracture. There was no skull fracture.
And as a medical examiner, would you also reasonably rule out one of the other four, like suicide?
Oh yeah, I would rule out suicide.
Can you, from the evidence, sir, rule out accidental death?
3-year-old.
No.
Now, there's a difference between cause of death and manner of death, correct?
Yes.
What, if any, opinion do you have, sir, as to the manner of death in this case?
The manner of death means, like I said already, natural causes, accident, suicide, homicide, and natural causes. There are 4 classifications for manner of death. Cause of death is something else. Cause of death is pneumonia, gunshot wound, lot of causes of death. But manner of death, there are only 4. Homicide, suicide, natural causes, or accident. So,
In this case, do you know what the manner of death is?
the manner of death, I would not be able to tell you. Based on the examination as it stands today, I could not tell you what the manner of death is.
Now, sir, finally, do you know approximately how many autopsies you have conducted in your career around the world?
I have either conducted or supervised the residents doing autopsies on approximately a total of 60,000.
60,000?
60,000.
I have no further questions.
I've been practicing forensic pathology for 56 years.
Hang on just one second, please.
60,000.
No further questions. Thank you very much.
Okay, we'll take a 10-minute recess before we proceed with cross-examination. Okay, stay recognized, presence of the jury.
I do.
Defense?
Yes, sir.
All right, you cross-examination.
Doctor, if you could kind of turn that screen a little bit, because I can't really see you down there. Thank you. That's perfect. We'll have you look at the screen in a minute, but for right now, that's great. Doctor, a medical legal investigation, particularly in determining manner of death, requires consideration of of information outside of merely the medical evaluation of the remains, doesn't it?
That's correct.
What information about this case, that is the investigation of this case, were you given in order for you to render the opinion you rendered on direct examination?
Well, I was given information of the first autopsy, whatever is included in that autopsy report. I was given information, I was permitted to go to the scene of where the body was found. I went to the house as well, to the house where the people that have an input into this case resided.
The Anthony home.
The Anthony home.
Okay.
I was, well, that's about it.
Well, but in order to do an adequate medical legal investigation involving manner of death, you need to know the surrounding circumstances revealed by the investigation, not just the medical aspects, but the entire background.
I understand that. And I asked questions of those who know about the case. I asked to give me information that I wanted to have, and I received that information. I cannot tell you now each and every question that I asked, but I asked sufficient questions to allow me to have a good idea about what I think happened here.
Who did you ask?
I asked, well, Mr. Baez, I asked. I asked Mr. Mason. I asked, well, I think I spoke, if I'm not mistaken, I spoke to the people in the home, some of them that I met over there.
Who did you speak to? Did you speak to the Anthonys?
In the Anthony home. I don't remember who those people were.
Did you read any of the police reports?
I did have police reports, yes.
Oh, okay. Well, you hadn't mentioned that. Tell me about
Yes.
the police report.
That's right. I had those too.
Which ones?
I couldn't tell you. I didn't know that there were.
Tell us what your
different
understanding of the predicating facts of this case are leading up to the finding of the body. What is your understanding? Those facts that you used in your
being
testimony, your
questioned.
determination and opinion you gave to Mr. Mason on direct.
Well,
What
I
are the facts that you
understand.
know?
I understand that there was some time, a lapse of time of a month between the disappearance of the child and when
Word.
a police report was made.
Now, aren't the facts of the last time anyone saw a victim always extremely important in a medical legal investigation?
Yes, everything needs to be evaluated together, but not independently. That's why everything has to be fitting together like a jigsaw puzzle.
So I'm sorry, are you done?
I'm sorry?
I just want to make sure you're done with your answer. You paused. I want to make sure that you were done before I go on.
It all needs to fit together. You cannot take one item by itself, but you have to evaluate the entirety of the picture.
What is your understanding of the events of the last time that Kaylee Marie Anthony was seen alive?
Would you ask me that again?
Sure. What is your understanding of the events of the last time Kaylee Marie Anthony, that's the victim in this case, was seen alive?
I know that Kaylee Anthony was allegedly taken to a babysitter. Is that what you mean?
That's
my understanding, that's something that occurred when she was.
I just want the jury to know what information you had about the background of this case, which you acknowledge is essential in coming to the opinion that the manner of death is undetermined, as you expressed to Mr. Mason on direct. I want the jury to know what facts you had in making that decision. So please explain that to us.
I don't know that I had any facts on when she was alive. I cannot recall information that I had that allows me to recite for you what she was doing or what happening to her when she was alive.
Hey,
Well,
let's
then, would you not agree that Dr. Garavaglia had considerably more information than you do in coming to her opinion that the manner of death is homicide by undetermined means?
Well, if she knew that information, I'm aware of whatever she put into her report. And that's a fairly lengthy report if you consider all the anthropology and toxicology and microscopy and whatever else is in that report. but I do not recall any information that she had that I did not have because I read her report.
Well, but
So if you tell me that she wrote something in that report that I did not tell you, then,
This is the state.
well, I had that information and I would have read
Ew.
it. So I would have been aware of whatever that she wrote in her report. I was totally familiar with.
what did she write in her report about the predication of this the last time she was alive? What did she say in that
What
report? Do
say
you
on the
recall?
stand?
What she said?
What Dr. Garavaglia said.
No, I don't recall.
But it is common in forensic pathological reports to summarize relatively briefly the facts of the investigation, correct? It's not generally a practice to put in every single fact that you may have learned, but rather to summarize them.
Well,
Isn't that
some
correct?
people do and some people don't. I don't, but many people do.
But to do a complete medical legal investigation, one must look to all possible sources of information, at the very least, read the police reports and statements of witnesses to determine exactly what led up to this child dying. That's essential, isn't it?
Yes, and therefore we do read police reports.
But you've just told us that you don't remember any of the facts of this case or
No,
what
but I
happened to
didn't
her.
tell you. That is not,
Okay.
not, I don't think that's correct.
What do you
That's
remember?
paraphrasing what I said. I did not say that I don't recall any of the facts. I do recall facts that I considered significant for me to formulate an opinion. And you asked me what I knew about Casey Anthony
Peggy,
before
this
she
is the
disappeared,
most
before she
forensic
was
pathologist.
before she was when she was last seen alive, and that I do not recall. I recall is that she was a healthy young 3-year-old child.
Autopsy.
Well, let me ask you this way, to be fair. What do you recall about the facts leading up to her disappearance or death that you considered significant in coming to the opinion you expressed on direct?
MLK.
Not when she was last before she was last seen alive.
Well, if you did not consider that fact significant, that's fine. But tell us what facts you considered significant about the time leading up to her death or disappearance that you felt were significant.
Well, I thought that there was a pool in the house in the yard, which I saw when I was there, which creates a possibility of drowning. I understand that for a month went by without informing the authorities that the child is missing.
Do you recall any other facts of significance?
No, I don't recall other facts. If you want to remind me of them, I'll be glad to listen.
I'm just inquiring of the ones that you felt were significant in rendering the opinion that you gave to Mr. Mason on direct. And those are the facts that you found significant.
Yes, and that is a fact that I understand that she was missing for a month.
Now, you also indicated in direct examination that the failure of Dr. Garavaglia to open the skull was a violation of protocol.
Correct.
What protocol is that?
The protocol is that we have here an autopsy on a child that has was the ultimate examination by a forensic pathologist in a case that had made national news. We open the head in.
Your objection, non-responsive. The question was what protocol was violated?
Doctor, do you understand the question?
Yes, I understand the question, Your Honor.
Okay.
So what protocol was violated?
The protocol is that the head is opened.
Peggy, let me put it this way. He was around practicing medicine before Israel was Israel. He literally said that when he started, when they started asking him questions. He was like, I went to the Hebrew school and it was just still Palestine. He's the GOAT.
In any
Like the
individual
LeBron James.
where there is a possible involvement
Yeah,
of
they didn't
the,
open the head.
skull, the meninges,
That was a
the brain, and any structure that would theoretically benefit from a skull examination, from an opening of the skull. Let me say this, that the skull, the head, is part of the body. And when you do an autopsy, you examine the whole body. That's just like when you buy a house, you buy a whole house, not a house without a basement. If you want to have a house without a basement, maybe you can find one. But in general, you buy a whole entity. And that contains a living room, a dining room, a bedroom, with this kind of stuff. And it's a complete structure. The body is a complete structure. The head is an extremely important item in all this. There can be all kinds of things in a head that occur that you need to know about. You mean to say that I examine only from the head down? The rest is of no significance?
Doctor, what I'm asking you is, where is this protocol published?
There is no publication. This is part of the. I don't know where that is published, but I do know that I have been trained, and I have trained lots of medical examiners to practice forensic pathology. And there is somewhere that I'm aware of, because I was a member of the committee that made that document, that what we should examine. But I don't know what that's called. I've been out of the mainstream of administrative forensic pathology for some time now. But to not open the head, I think, is a failure of the autopsy. And I'll tell you another thing, that if an autopsy was done in a corresponding to what I think every forensic pathologist will tell you, where the head is not opened, that tells me about a shoddy autopsy. Excuse me the expression, but you provoked it. A shoddy autopsy, because if the head is not opened, what else wasn't examined?
Sorry, I apologize. I didn't mean to provoke you.
Yeah, it is. It upsets my better knowledge, my better understanding of my profession that I've now practiced for 56 years. That somebody would do an autopsy.
Let me object. Excuse me, sir. I would object to the narrative and not responsive to the question.
Let's have another question.
Thank you. So, a skull is opened in an traditional autopsy of a non-skeletonized remains in order to examine the brain within the skull and the structures within the skull. Isn't that the reason?
No, that is one reason, but it's not the only reason.
Okay, all right. If you guys have been watching for a couple of days, this is the kind of like accepted behavior for forensic pathologists, because the Orange County lady who did the autopsy behaved the same way. This is wild.
What other reasons are there?
Well, each case beckons a certain examination of certain things within that same location, namely the skull and what else is there. I would never have known how this head was positioned, for example, if I didn't open it.
We'll discuss that in a minute. But what I want to establish is there's also a protocol for an autopsy that requires the opening of the chest by, is it cutting the ribs along the sternum?
Well, you're not going to have access to the chest organ if you're not going to open the ribs, just as little as you're going to have access to the brain if you're not going to open the head.
So certain protocols apply to non-skeletonized remains don't apply to skeletonized remains, because you can see what's in there because everything else is gone, correct?
No. You mean you can look inside the head without opening it?
Yeah.
Well, you have to show me how to do that.
There's a little hole right in the bottom.
I'm sorry?
Isn't there a little hole right in the bottom?
I'm sorry, I don't understand.
I'm sorry. I'll withdraw the question. Now, are you aware of any...
in the asshole?
You're aware of this book, correct?
Yes, somewhat, yes.
Well, you edited it and wrote some of it.
Exactly.
And this is a compilation of articles on virtually every subject in the area of medical legal investigation of death. Isn't that correct?
Well,
sorry. Medical legal investigation of death by Spitz and Fisher, the same book that Mr. Mason asked about a moment ago.
It is a textbook in forensic pathology.
And it contains articles on virtually every aspect of medical legal investigation. Some of them you wrote yourself. Is that correct?
Yeah, I wrote most of the trauma chapters.
There's chapters on forensic anthropology.
Yes.
And those are written by William Bass, that we've heard, whose name we've heard a number of times in this case. There's articles on forensic entomology.
Yes.
Written by Neil Hassel, correct?
Correct.
Now,
we can't hear you when you don't have a friggin' microphone.
Would you agree that this is an authoritative treatise on the medical legal investigation of death?
Yes.
Like week 4.
May I approach the witness?
Yes.
Turn my microphone on. Can you show me where in this book it establishes a protocol that requires the opening of a skull in a skeletal case?
So this is not a book on protocols. This is a book which talks about findings and interpretations of wounds and what happens to a person after death and things of that nature. This is not a book that tells you about how to do an autopsy. It tells you how to interpret injuries. And you will find by reading this book that the head is opened in just about every type of autopsy one performs, because it shows you injuries in the head. And to find those injuries, you need to open the head.
And in the chapter on forensic anthropology written by William Bass, does it contain a protocol which suggests that the skull must be opened in the...
I've had it with him. I've had it with him.
Mr. Mason, you need to repeat your objection. The court reporter did not hear it.
I'm objecting to the prosecutor's efforts in violation of 611 regarding bolstering of his witnesses or attempting to.
Overruled.
The question was the chapter on forensic anthropology in this book that you edited.
Yes.
Does it contain any protocol or requirement that the skull be opened in a skeletal case?
This is not a book on protocols. It probably doesn't say that the head needs to be opened in anywhere in this book, because but it does talk about injuries and findings in a head that occurred during lifetime, and in order to find those things, those manifestations, the head needs to be opened. So whereas it doesn't say that go ahead and open the head, it talks about the findings in that head which require the head to be opened.
Now, are you familiar with something called the Minnesota Protocols? It's a UN document. The full title of the document, for counsel's benefit, is Manual on Effective Prevention and Investigation of Extralegal, Arbitrary, and Summary Executions, specifically Section 5, titled Model Protocol for Disinterment and Analysis of Skeletal Remains. Are you familiar with this document?
I know nothing about that. If you can, maybe you can tell me who wrote that.
It indicates it was drafted in consultation with lawyers for the Advocates for Human Rights, formerly the Minnesota Lawyers International Human Rights Committee. This manual, which supplements the principles of effective prevention and investigation of... Actually, let me make a report and let him read it.
Yes.
Thank you. Somebody come here for me with it.
I don't know if you guys have noticed, but these sunglasses aren't even straight on me. Look. They're like down, up.
You know, this is written by lawyers, for lawyers, and as I said, by lawyers. It's written in legalese. I don't understand it. I'm not a lawyer.
Would you
never have been a lawyer, and I don't know how even to understand this document.
Would you read the, I think it's 3 or 4 pages in, it's Section 5, the model protocol for the...
Objection, Your Honor, is improper effort to impeach with a non-recognized, non-authoritative source.
I'm just trying to determine whether he recognized it, not read out loud, but read it himself.
Look at Peggy's comment. Look at
This claim,
Peggy's
he's
comment.
indicated he does not recognize it.
Well, I just thought he might, if I may have him just to himself review that Section 5 to see if he
Water.
recalls that section as opposed to the lawyer
Coke.
E's part.
Okay, look at that section, Doctor.
Would you show me which section that is?
You might.
Cookies. I don't even like sweets, but I saw that they were soft baked lemon cookies, and I like lemon.
Recognize, never having seen it.
No, I've never seen it. I can tell you that.
All right.
Yes.
So, Doctor, it would be fair to say that when you, on direct examination, said that Dr. Garavaglia's failure to open the skull violated protocol, what you really meant was it violated the way you think it should be done, correct?
No.
So there's no written protocol anywhere, correct?
I did not say that. I am not aware of a protocol, but I can assure you that investigation of the head is part of a complete autopsy. And that we are dealing with a need for a complete autopsy in a nationally
I think that's exactly what
in
it
a case of national significance, because this is shown on all televisions and newspapers, and they all talk about this case. And therefore, wouldn't you think that an autopsy is required to document all the findings and not only those below the head?
Now, you've said that twice, actually pointed out the high-profile nature of this case. That's a significant fact to you, isn't it?
Which one?
The fact that this is a high-profile case of, you said, national significance. That's a significant fact to you, isn't it?
Of course it is significant. It is significant that that the pathologists recognize that this case maybe requires more questions to be answered than somebody 85 who is found dead in bed from heart disease.
So you think that the fact that this is a high-profile case means that it should be done differently than somebody that nobody knows or nobody cares about? Is that what you're telling us?
No, that's not what I'm saying, sir. There is no case which nobody cares about, because there are always relatives, and there are always people who want to know, and there are people in this case that want to know. And they not only the people in the family want to know, but the police want to know, and the people in the street want to know. That's why the television broadcasts it. That's why it's high profile. But that's not the only reason why you open the head. You open the head because that belongs into a complete autopsy.
How many media interviews have you given about this case since you were hired? How many?
I have given one interview that was for a local station here in Tampa, in Orlando.
What?
And then somebody called me from a local paper in Detroit and asked me about my coming down to Orlando. That's it.
Didn't you do an interview with a Detroit TV station as well? I think it's TV6 out of Detroit this very week.
On which station?
Out of Detroit, your hometown, out of Michigan, I should say, up where you live. Didn't you do an interview that was televised on the local TV station up in Michigan where you're from this week?
That's the one that I mentioned to you. That's the only interview that I gave for television on this case for the local consumption here in Orlando. I gave it in Detroit, but it was broadcast to Orlando, and they broadcast it here in Orlando. And in addition to that, a newspaper learned, the Detroit News learned that I'm coming down to Orlando and called me and asked me when I'm going and what I'm going to do and so on. So that is what the extent of my media response to this case.
Well, you gave an interview to a gentleman by the name of Tony Pipitone. I think he's not here today.
Ask your question, sir.
Certainly. Then you also gave an interview this week to a female reporter for a local station in Detroit, didn't you?
Oh, wait. Oh, no. Hi.
Yes, I think I did. That was also in response to, I don't think that there were a lot of facts in that case described about, or any facts about this case. There was mostly a logistic that I'm actually going down. There were all kind of other issues discussed in that interview.
You don't recall in that interview with the female reporter for the local station discussing at length your testimony in this case, your theories about brain dust, your theories about tape application? You don't remember
what
discussing
application?
About tape being applied to the skull? You don't remember having this conversation?
This was that's correct. I did talk to her, but I don't remember what I talked to her about, because this was shown and I was meaning to watch it, and then I fell asleep as it was being aired.
Believe me, I can sympathize after this week. But you were also on the Today Show back in June of 2009, were you not? Giving opinions about this case.
Skull dust.
You recall being featured on 48 Hours on a nationally televised show about this case.
No, I don't remember that.
You like high-profile cases.
Yes.
Don't you?
No, I don't like or dislike. I look at the case to render opinions about that case. But whether it's a high-profile case, every case to me is high-profile.
You were involved
That's why I open the head in every case.
Were you involved in the Phil Spector case out in California?
In the Bill Spector case, yes, I was.
You were involved in O.J. Simpson?
Yes, I was.
You were involved in the Menendez brothers case
No.
out in California?
Ooh. No.
Didn't get that one?
No.
Well, why would he? Oh, I mean, the mom and dad.
Let's talk about
Makes sense.
the residue in the skull. Where that exhibit? Now, one other question. Oh, I'm sorry, it's exhibit AZ. It's not in evidence?
Newsflash, if you are really good at something and you are considered like the Michael Jordan of your profession, soak it up. Grift the hell out of it. Be the best there is that you can possibly be. Like, do all those interviews. I'm just saying.
Oh,
It's
I'm
a
a
blow up
capitalist.
of.
one minute.
Sorry.
Defense 26. Okay, thank you. Just as a parenthetical, when you opened the skull, you actually broke it, didn't you?
When I opened the skull, what?
You broke it.
When you
I broke it?
Yes, when you opened the skull, you broke it.
take a moment, think about what was just asked. When you opened the skull, you broke it, didn't you? I'm sorry, what?
Didn't you, Dr. Spitz?
I didn't know that I broke it.
Look, can you see the crack in the skull right here?
Yes, there is a break there, but I didn't do that. I don't know that I did that.
Oh, okay. This residue that's in the skull that you're relying on for your opinion, did you have that tested, chemically tested?
I did not do any chemical tests. What I did was I scraped some of that and gave it to.
Right. He didn't. People want him.
I kept it for possible testing. Then I was told that this was tested by the county or the I don't know who tested it, but as far as I understood was that it found its way to the police, that they tested it, or some police laboratory tested
Who
it.
told you that?
I don't remember who told me that.
Well, my point is, doctor, you don't really know whether that debris, whether that residue is brain dust or just dirt, do you?
No, that's not dark. That is debris, because it is part of, that is the settlement of a decomposing brain and surrounding soft tissues by gravity. That's what this is. Please believe me that this skull of Casey Anthony.
You mean Kaylee Anthony?
Kaylee Anthony is not the first decomposed skull or
but Dr. Spitz,
decomposed skeletal remains that I've opened.
I did too,
and
Georgina.
found this kind of a residue. This is a routine finding, and it's mentioned in my book that these things occur and should be examined.
now, but without examining it, you can't truly know whether it's brain dust or just dirt. I mean, isn't that true?
No, this is not just dirt. This is the residue from a decomposing brain, and it goes by gravity to the lowest point. That's what this is.
Now, did you get information about the nature of the area where this skull was found?
I have to stop because maybe will kill me if I don't. Please make sure that you have liked the stream. Check right now, please. Look at my screen. I'm going to go ahead and like that. I just did that on the screen. If you could do that for me, that would be fantastic. And please go ahead and subscribe while we're there. I'm really close to hitting another 1,000 subscribers, which is like friggin' bonkers. Let's go. Thanks, guys.
I went there.
Keep it
And
going in
you-
the chat.
you
I
would
love
agree
the
that it's a
discussion.
area that is, well, were you given information that this area is an area that is at least
Anti-Semitism
occasionally
is really
underwater?
kind of where I draw the line. So maybe, thank you.
based on the seasons?
Yes, I understand that too.
All right. So if this skull were underwater, are you telling us that there's not a possibility that that residue that you identify as brain dust is simply sediment from water?
Yes, it is a sediment. That's correct. It's a sediment of the brain decomposing and falling to the lowest point.
It couldn't be sediment from dirty water that infiltrates the skull as it sits underwater.
I was in a Jewish sorority, so you must not like me.
You know, this sediment is so common in skeletal remains that have been subjected to extensive decomposition of the brain and soft tissues, that it is almost as definitive a finding as to say that here, this is a lower jaw. I don't need to research the background of this to say that this is the mandibular bone in an elderly individual, a human. So this, I don't need that, because this speaks for itself. The same as this speaks for itself, and the same as that speaks for itself.
So you don't need to bother to actually have the sediment examined by a chemist or a geologist or a mineralogist or anyone else. You know beyond any doubt that that's brain sediment and not just dirt. That's what you're telling us.
Well, if somebody would analyze it, that would be fine with me. Until such time that they analyze this, that is my opinion. That's correct.
Now, you do realize that the interior of the skull was washed with saline by the medical.
The quickest way to get kicked out of my chat is fucking with Peggy. That's like Peggy or maybe, and then the other mods. So if you're just like looking to casually get kicked out of somewhere in a free speech group, that's the easiest way to have it happen. Thanks.
Examiner and a toxicologist to see if they could get any trace elements that might have remained on the skull through decomposition. You're aware of that?
I'm aware that the medical examiner took salty water, so-called saline, put it in through this opening, this hole, where I put my finger or where I put my pen.
I don't hold on to grudges.
And then swished it around and removed whatever came back.
The cat.
So there's absolutely no possibility that that act of swishing water is why there's no sediment on this side of the skull.
No, the reason that there is no sediment on the other side is because that sediment has a weight to it. As I told you, this is not the first skull that I've examined. In fact, I was able to solve a murder case in California in a
Objection, not responsive to the question.
Sustained.
Which objection, Judge?
Mr. Mason's objection.
All right. Go ahead, Doctor, you can finish.
I was requested by the prosecutor of Riverside County, California, to examine a skeleton from Riverside that was buried in the mountains of Riverside and to determine the cause of death. And I opened the skull, and lo and behold, there was the same residue as here, sedimented down to the bottom, and I found it loaded with sleeping drug medication.
Oh.
And on chemical analysis. That is why the finding here was of such importance. It indicated, when I looked at the skull, I determined that the skull must have been on the left side. Otherwise, that wouldn't be there. So if you tell me that there was brown sediment everywhere, well, this brown sediment obviously does not respond to the swishing of the fluid. This sediment stayed put. Why did it stay put? Because it's sticky. It is sticky in the other cases that I've examined also, and it sticks to the bone. That's why it's there now. And that's why it will be there for probably longer period yet.
But in the other case, you sent the sediment for chemical analysis, didn't you?
I'm sorry?
The California case that you were telling us about?
Yes.
You sent that residue for chemical analysis.
Well, that's because there was somebody to give it to, and that from the prosecutor's office that picks it up. That is one of the advantage of two people doing an autopsy together. Because if that skull...
Your Honor, not responsive to the question.
Overruled.
Go ahead, you can finish.
Because if I had been there with Dr. Garavaglia, I would have insisted that I would have told her, you know what, let's take that and send it to the laboratory. Then we wouldn't have all this kerfuffle about determining what is what when you inject fluid into a closed box, swish it around, and then now we are arguing about where it came from or what it was.
But if you had the residue analyzed, we also would avoid the kerfuffle.
But I'm not a laboratory. I don't have a laboratory like that. I can do autopsies, but I'm not a chemist. I don't do tests like that. The laboratory does that.
Could you put your skull back together? I want to ask you a couple questions and use that skull. Okay?
You want me to put that back together?
Can you put it back together?
Can you put your skull back together?
You may.
Oh my gosh, we're so close, guys. Keep liking, keep subscribing. This is incredible. This is absolutely friggin' incredible.
Do I need to put this back too?
Yeah, please put it back. We're going to talk about the whole run.
Oh, hold on. Dog food.
I think we just want to put it in place. I don't know if we need to spring action to work. It's possible to play without it. Now, your theory is that this skull decomposed on its left side or right side?
Left side.
So,
With the face slightly elevated.
say like this.
Slightly at an angle, slightly like this.
Slightly like that.
Yeah.
All right. Now, it was at the time, I'll hold it. At the time of decomposition, when the skull gets in this position, the brain is still at least relatively intact, in your opinion, correct?
Yes.
The skin is still on the face.
Yes.
The hair is still on the skull.
Yes.
Correct?
Yes.
As it decomposes, everything decomposes together. Correct?
Yes.
The brain is decomposing
Yes.
and the skin is decomposing.
Right.
And the hair is sloughing off the skull. Is that correct?
Yes. That's right.
And by force of gravity, the hair would naturally fall this way. Correct?
No, the hair, the hair would move, but whether it would directly fall, I'm not so sure that it falls.
Well,
The hair is, the hair kind of is clumped together in clumps, and much of the tissue receives some of that creamy, soapy stuff that keeps the hair together, and so that even when that eventually disappears, the hair would stay put on the skull.
the hair would stay put on the skull.
Well, it
even
would
though-
move. Then people come and move it, and as soon as you touch the thing, the hair gets moved along too.
And doctor, if you could not interrupt my question, so I'll get it out and then wait, the court report's not going to have a problem. Now, so you're saying that the skull in this position and the skin has completely decomposed, the brain is completely decomposed, but the hair is still on the skull?
Well, much of it probably would be, yes.
But most of it would have fallen, correct?
Well, only that hair that would be on the left side may so-called fall, if you like. The hair that's on the right side must stay put. And you can see that there are structures on the head that would hold the hair, like here, the maxillary bone, that would hold it in place. The hair would be entangled in that, some of it.
But the mass of hair on the top of the skull would fall.
But not from the right side. It wouldn't go, the hair doesn't go up. The hair goes by gravity, it would go down, not up. And when it comes down from here, it would encounter this structure, and it would encounter that structure on the other side too.
I understand that. What I'm asking you is about the mass of hair on the top of the skull would be expected to fall this way.
Some of it would fall that way, some of it would not.
Well, you would expect if you found the skull in this position that the mass of the hair would be on this side.
No, that's not so. That doesn't happen.
So where would it be then?
Some of it would be stuck to the top and stuck to the right side. There would be hair.
It certainly wouldn't fall off the back though.
The hair from the back, some of it may be spread to the back when the skull is picked up. That hair would probably, being that it is resting on some of the shrubbery there, would stay on the shrubbery because it comes in with that sticky material that's on it.
219.
Not sure.
Doctor, do you recognize, can you turn your screen so you can see it? That one right there. I'll show you a photograph. Do you recognize this as a photograph, one of the medical examiner's photographs of the appearance of Kaylee Anthony's skull and remains at the medical examiner's office?
Yes.
And this is in evidence. May I publish, Your Honor?
Right.
Now, you would agree. Always forget about the delay. Thank you, sir. You would agree that the mass of this hair, the vast majority of the hair, has fallen back, not to the side. Wouldn't you agree?
And that's him.
Sir, you're looking at this picture.
That's him.
Shows the skull like this.
Correct.
Like this.
Yes, sir. And the hair mass has fallen to the back of the skull, not to the side. Isn't that shown in this photograph, Dr.
The
Smith?
hair is the hair that she has long hair, and the hair is sitting on the base of the skull. if you look at this, the back of the base of the skull has, and the sides here has hair, and the hair is sort of glued or sticky to the bone. That is that hair which matted itself to the skull when the skull was placed, or when the head was placed in that location.
But you would agree that this
And,
photograph
excuse me,
indicates, excuse me,
excuse
sir, Mr. Spitzek, you need to, let me finish the question. You would agree that this photograph shows that the hair mass has fallen backwards, not to the side.
Let me do my
Wouldn't you agree, sir?
finger. All right.
The hair
I
on this
need
picture,
protection
location-wise,
from
speaks
shade,
for itself,
things
where
from-
it is. And much of that hair is on the base of this skull. Like here, let me show you. If this is the matted hair, if this is the matted hair, this is the matted hair, skull is like this, and the hair would be here, here, and here. That's what you are seeing.
So your,
That's what you are seeing.
your
Let
recollection,
me show the gentlemen, ladies and gentlemen, that's what you would see.
So,
You would see that is what this picture shows.
doctor, so is it your statement that the photographs show that there is hair, a considerable amount of hair on top of the skull, that it hasn't all fallen, almost all fallen to this back and the sides?
I don't see any evidence on this picture of what you call fallen hair. This hair is matted and is, you tell me that there's water, maybe the water washed it to the water washed around it and splashed the hair onto the bone and wetted the liquefied scalp to the bone and attached it to the bone, glued it to the bone.
So the water displaced the hair,
Maybe,
but it didn't displace the residue.
I don't know if that's what happened, but that could have happened. And it seems quite likely because that happened because there is no hair on the base of the skull. So now there is hair on the base of the skull on the outside, on this surface, on the outside. How did that hair get there? There's no other way for the hair to get there.
The hair can't just slough off the skull when the skin which held it to the skull has decomposed and no longer exists.
The hair, in order to not exist, it underwent a process like adipocery or melting down, breaking down, and that yields materials which are sticky.
Did you look at this hair?
On the pictures.
Do you know whether it's sticky in its present condition?
Well, I know that it's sticky because I've examined other hair, not this hair. But I mean, that is a fact that this hair was not located in a clean, what we call clean environment. This hair was subjected to decomposition. And when decomposition finishes, the dried up adipocery is still there and helps stick the hair to the bone.
You would agree, however, that this photograph does not support the position that you have theorized the had decomposed it, because the hair has not slid to the side.
No, I don't see why that contradicts it. This is to be expected. If you said about this area is submerged at times, and that would be totally consistent with it.
And now.
Now, let us proceed now to your other theory about the duct tape. Is it your opinion that the duct tape was applied to the skull after it was fully skeletonized?
It is my opinion that the duct tape was stuck on there after the skin had deteriorated, after the skin was decomposed.
How did
through the whole process of adipocery, you see the skeletonization here. You see it. It's looking at you. It's looking at me. It's almost in this condition, except it's not been handled, at least not much. At the scene, there's debris. There is because that area is full of debris.
No, may I object to the narrative? It's not responsive to the question I asked.
Damn it.
Doctor, had you finished answering the question, sir?
I have, yeah.
Okay, thank you, sir.
Now, how did this person do that? Describe for the jury how, in your opinion, this person actually did that. Put duct tape on the skull.
I'm sorry, I don't. How the person did what?
How this person that you have hypothesized put duct tape on the skull, how they did it.
Well, they took a piece of duct tape in a roll. It comes in a roll. I'm sorry I didn't bring you a roll to show you. I have a big roll in my office, and tore off a number of sections, maybe this long, and stuck them on the skull to possibly to do what I did, so that I can show it with strings attached the lower jaw, the lower jaw to the rest of the face.
Well, let me start with the first level. Is it your theory that your theory is that the skull and the body decomposed at the location where it was found, but on its side? Do I have that correct?
On its left side, yes.
Right. Did the person, in your opinion, come over and pick up the skull from the ground?
Coco, no.
Is that your theory?
You mean, I don't know if the duct tape was applied when the skull was on the ground, or whether the duct tape was elevated when that was done. That I cannot tell you.
Well, how
I mean, I'm a fairly good forensic pathologist, but I cannot tell you an answer to that question, whether it was elevated or whether it was on the ground.
Well, if the skull is on its side, someone would have to pick it up in order to place duct tape over the front going to the sides. Correct?
Maybe. I don't know. Maybe yes, maybe no.
Well, and when they picked up the skull, the mandible would have stayed where it was. Correct?
The mandible would have what?
In other words, when they picked up, if the body is completely skeletonized, then the mandible and the skull are not connected. Correct?
Well, they are connected until the skull is moved around, and then they're not connected. It's not connected because the soft tissues that hold the skull to the lower jaw, those are gone. So it's like I said earlier, when I picked up this skull, the mandible, the lower jaw, which is the mandible, fell down here on my bag.
Exactly my point. This person had to pick up the skull and then pick up the mandible, because they would be separated, correct?
Unless you use duct tape and stick it back on.
But he hasn't duct taped it yet. We're getting there.
Well, okay.
He picks up the skull, he picks up the mandible.
Yeah.
This person then would need to place the mandible back in anatomical position in the skull. Isn't that correct?
Possibly. I don't know how well it was attached. I don't know. In the pictures that I see here, there is no mandible on this picture anyway.
Correct. But do you recall from the report of the autopsy and the forensic anthropologist that when it was found, the mandible was in virtually its anatomical position?
Right.
So this person would have had to take the jaw, put it back in anatomical position. Correct.
Yes.
He then would have had to have taken a piece of duct tape and placed it around the bone itself.
On one side.
Well, do you recall from your readings that the duct tape is on both sides?
The pictures don't show it like that. I don't have a picture. Maybe you have a picture. I don't remember a picture that shows it on both sides.
This is the state's attorney, just so you guys know.
We'll just take, for purpose of my hypothetical, that it's on both sides, and the jury will see has seen the photographs already. So he would have had to take. Here's another point: if you're trying to attach the mandible to the skull, you'd have to do it on both sides. Correct?
Make it stop, right?
If your theory is correct.
Well, that depends on how long the duct tape is. I don't know whether it was on both sides. I remember it on one side, and the other side, there was no duct tape that I could see. But if you tell me that there was duct tape on both sides, so okay, so there was on both sides.
But if your purpose, as you've hypothesized, is to connect the jaw to the skull for some reason, you'd have to do it on both sides.
If you want a better bond, yes.
This person actually, though, would have done it with 3 different pieces of tape.
Oh,
You're aware of that?
I know that there are 3 pieces of duct tape.
So why would it take 3 pieces of duct tape to stick the mandible to the skull if in fact that was what you wanted to do?
Well, because there was, what I gleaned from the pictures again, there were 2 pieces of duct tape superimposed one on top of the other, and the pieces were not terribly long to reach the other side. So maybe one side was done, and then there was another piece of duct tape put on top of that, so that would extend the total length of the duct tape to afford it to be on both sides.
For purposes of our discussion, you may accept that the pieces were 6 to 8 inches long each, and there were 3. For purposes of our discussion. Pardon?
It was what?
Each piece was 6 to 8 inches long, and there were 3 pieces.
There were 3 pieces. One piece was like 9 feet away, I understand.
Yeah, the 4th piece was 9 feet away.
Yeah.
Right. Okay. So this person would have taken this skull for whatever reason and cut 3 pieces of duct tape and.
Okay, so this guy was brought in from the defense. He is the god of forensic pathology. He did he helped with MLK's, Kennedy's, John Benet Ramsey's. He's brought in, he just died, so I'm talking about him in person, but he's very, very knowledgeable. He wrote the book on forensic pathology, and the state's forensic pathologist, I don't know why I'm like tripping up on that word. The state's forensic pathologist refused to allow him to sit in on this autopsy. She came and she testified, and you could tell she had a really big chip on her shoulder. I don't know what it was, but she was very argumentative. And now I'm starting to think it's like a professional thing that they're this way with one another. I don't know. But he is critiquing the way that it was done because the state didn't open up the skull. The state just made these what I would refer to as like rookie errors regarding this autopsy. And people are in the chat saying like, I mean, no wonder Casey walked. Yeah. When you listen to shit like this, of course.
Wrapped it around the skull, actually putting the adhesive on the skull itself. This is your theory, correct?
Yes.
Why is there no glue residue on the skull?
There's no glue residue on the skull. There was no residue of duct tape on my skin that I put directly on when I put duct tape on my forearm. There was hair on it, but there was no glue.
But this is bone, not skin. So why is it?
Why would bone be any different? In fact, bone is much more solid and dense than skin. So why wouldn't if it is there isn't any on skin? Why would there not be any? Why would there be the residue on bone?
You do realize that the duct tape was not.
What happened? We're gonna pretend like this.
It's not stuck to the bone.
Well, why isn't
Pictures
it?
don't show it stuck to the bone.
But why isn't it?
Well, because there's intervention of water. The water will usually remove some of the glue, the stickiness of the glue. So why not?
No, you didn't get kicked out.
So if this person removed the skull, attached the mandible to it, and put 3 pieces of duct tape on it, and then set it back where it was, is that your theory?
Or take it with him and then bring it back and put it back to where it was. Or take it to where he or she wants to put the duct tape and then bring it back and put it back in the place.
Then why is the hair the only thing that stuck to the tape?
But the hair would stick to the tape.
But you said that the tape was put on after the skull was removed. So how can the hair be stuck to the tape?
I don't know how the term stuck to the tape is applicable here, because I'm not so sure that that the tape was really still in a condition that it enables stickiness, that it preserved the the tape preserved the stickiness through this entire ordeal. Heat, water, that takes away some of the stickiness.
For purposes of our discussion,
Yeah.
would you accept, or do you recall from the autopsy report that Dr. Utz, the doctor that removed the tape, had to cut the hair in order to remove the tape because the hair was stuck to the tape? Does that sound familiar?
Well, some of this, yes, I did. Some of this hair is probably there, and some hair will probably not be there. So some of the hair she may have had needed to cut, and some of the hair she did not need to cut.
Could I have it State's Exhibit 215 and published to the jury, Your Honor?
Right?
You see this photograph, Doctor?
Yes.
And then this person who picked up the skull, attached the mandible, attached 3 pieces of duct tape, put it back, then had to drape strands of the hair over the skull. Is that your theory?
See, would you say that again? Because
Sure.
I don't understand what your question has to do with this picture.
Do you see these strands of hair that are on top of the skull?
Yeah, they're just lying there.
Your theory is
These
that
pieces of hair, excuse me, these pieces of hair were put there. They did not stay like that.
they were put there.
Yes, the person who took this picture, or the person who prepared this picture for the photograph to be taken, put the hair there.
So your testimony is that the medical examiner's personnel took the hair that was not on the skull and placed it there for the purposes of this photograph?
Wouldn't be the first time, sir. Wouldn't be. I can tell you some horror stories about that, where people sat in jail for a long time because of somebody removing bloody clothes and putting them in the trash can, and those were police officers.
May I publish State's Exhibit 209 to the jury?
You may.
Do you see this photograph, Dr.
Yes.
Spitz? Do you recognize this as a photograph of the skull as it was found at the scene?
I remember when Jesus was on the cross. Let me tell you about the time. Oh, and they were throwing the stones. It was awful. It was awful.
Yes.
And do you see the strands of hair draped over the skull?
Yeah, but this does not look like, yes, I do, but I do not see that this picture is identical with the picture that you just showed me.
Is it your testimony that the medical examiners who took this photograph at the scene took the hair and draped it over the skull for purposes of this picture?
It is my opinion that somebody did. I don't know if it's medical examiner or not medical examiner. I cannot tell you that because I don't see fingerprints on this. But if you compare this picture with the other picture that you just showed me, they look different. And why do they look different? Because somebody rearranged it.
Read the rec.
Excuse me.
Dr. Spitz, you were asked a little while ago,
Don't bring him in.
Mr. Ashton, if there were any other reasons for opening the skull than the general autopsy protocol. Do you remember that question?
Yes.
Are there other reasons why you would open the skull?
This is what you
Sure.
do.
And what are they, sir?
Well, first of all, just for to mention, there, if you look at medical legal investigation of death, I don't remember the page number, obviously, but there are occasionally fractures that will not fracture the outside of the skull. So what does that mean? That means that here the skull put back together. If there is, let us just for the sake of argument, if this kind of a force is applied to the skull, of the skull, for instance, you can find, when you open the skull, you can find a fracture on the inside, but nothing on the outside. That's one. The other thing is that in a case of, in certain types of death, there would be hemorrhage to the, in certain locations on the base, in the base of the skull. I think I mentioned that earlier. In the area of the middle ears, in the areas of the this bone here behind the lower jaw, which would contain a coloring that's in the bone that is difficult to remove from blood that had accumulated there, which is not here, did not occur in this case. Another thing.
Excuse me, Doctor. What other types of death would cause that hemorrhaging and discoloration by blood on the base?
Well, it doesn't occur each time, but in a good number of times, there's hemorrhage in those locations in cases of asphyxiation by smothering or by strangulation.
And how does that occur?
Well, because if you smother somebody, the blood pressure goes up in the head area, and then blood vessels break, and that's the location where you get the evidence.
So in many occasions, if there is a suffocation, an asphyxiation, the blood pressure alone will cause there to be hemorrhaging and discoloration on the base of the skull.
Well, as I said, it doesn't happen every time, but when it happens, when the blood decomposes, it leaves a residue, and the residue is colored.
You were also asked by Mr. Ashton, sir, if you had sent the brain matter, he refers to it as dust, the sediment, for chemical analysis. And you respond, you did not.
No, I did personally not. I don't have the facility for that.
You read all of the reports from the autopsy by Dr. Garavaglia, did you?
Yes, I did.
Right. Did you learn that, in fact, the matters from the autopsy were sent to Dr. Bruce Goldberger, a toxicologist in Gainesville?
Objection, specification of what matters.
Pardon?
Relevance of specification of what matters.
Overruled.
Yes, I did.
And did you read the results of the toxicology screens by Dr. Goldberger, sir?
Yes, I did.
Did Dr. Goldberger find the presence of any form of poison?
No, he did not.
Did he find the presence of any amount whatsoever of
Objection,
chloroform?
scope across.
Overruled.
I'm sorry, I didn't hear the question.
Did he find the presence of any amount of chloroform?
No, he did not.
Now, the last issue Mr. Ashton was asking you about is the presence or locations of duct tape, right?
Yes.
Do you know how many people had handled that skull before it was photographed in the medical examiner's office, sir?
No, I do not.
Do you have an opinion by looking at those photographs, whether in fact of necessity that skull was manipulated to take the photographs?
Well, it had to be manipulated. I mean, there's just no way that it was not, because manipulated means, manus in Latin means hand. So manipulated means that hands were laid on the skull. Why do I know that? Because it's positioned on a brown paper for the purpose of taking a picture. Well, the skull didn't walk there. The skull didn't go there. The skull was put there by hands of somebody. And in the process, the hair had to be rearranged. That's why the hair in the office, in the presence of the camera, looks somewhat different than the skull, with the hair, with the position, placement of the hair on the skull at the scene. There's just no other way.
So somebody had to do it.
Somebody had to do it, sure.
No further questions, Your Honor. Thank you.
No questions from the state.
May the witness be excused.
Thank you, Your Honor.
Thank you very much, Doctor.
She went to live.
Okay,
with
ladies
my
and gentlemen of the
husband.
jury, this concludes the presentation for evidence today. We will see you Monday morning at 9 a.m. Please remember all of my other previous admonitions. Thank you.
1 second.
Okay, folks. So there will be no confusion about which order I was talking about. It was an order that was entered on January 6, 2011. Order granting state's motion for sanctions / motion to compel, which specifies the requirements of reports, what are to be included in those reports. So let's make sure you reread that in comply so we won't have any more hiccups. Be prepared next Saturday to work, if necessary, up to 3 p.m.
Yeah, we know. Ridiculous.
So we'll probably let
I
you know.
take off my sunglasses.
But
God, it's very
going
difficult.
through one witness a day is not going to get us where we need to be.
Well,
But at the same time, I'm not going to hurry you.
exactly.
We will just extend the working hours. So just be prepared to work longer on Saturdays. And if necessary, we may extend the work hour to 5:30, 6 o'clock.
That
But
was
I'll make that evaluation
shade
at the close of
protection
business
for all
on
the shade being
Tuesday.
thrown.
Okay. Any other matters we need to take up from the defense? Okay, we'll be in recess to 9 a.m. Monday morning.
Okay, we've seen this. Hold on. We have not seen that.
Pete, you found was
My name is Yuri Melish, Y-U-R-I-M-E-L-I-C-H.
Good afternoon, sir.
Good afternoon, sir.
You are the lead detective in this case.
Correct.
Okay. And as part of your job as lead detective in this case, you have executed several search warrants of the Anthony home.
Yes,
Okay. And the first one was in August?
I believe so, yes.
Okay. And at the time that you did the search in August, did you find any papers dealing with chloroform in the home?
I don't recall finding any papers in the home, no.
No printouts from our how to make it or any instructions on anything having to do with chloroform?
No, sir, not at all.
Okay. Did you find any containers that at one time or another contained chloroform?
No, not at all.
Did you find any rags that at one time were used to that had chloroform on them?
No,
Did you find any products that were used to make chloroform?
no,
Okay. Did you find any receipts on purchases of chloroform?
no,
Did you find any chemistry kits of the kind that might have been used to make chloroform?
no.
Okay. You then executed a second search warrant in December, on December 11th of 2008, correct?
Yes,
And on that occasion, did you find any receipts of purchases of chloroform?
no,
Did you find any containers that may have contained chloroform?
no,
Any rags or any cloth material that might have contained chloroform?
no,
Any chemistry kits that might have contained chloroform or been used to create chloroform?
no,
Any of the other items that I previously mentioned?
no, sir.
Were you looking for that?
I'd have to check the search warrant to see what was listed as far as the scope of the warrant.
If I
But I
showed
believe,
if I showed you a copy of the warrant, would that assist you?
yes, please.
May I approach the witness, Your Honor?
You may.
Thank you.
Where you're specifically looking at the search warrant of December 11th, is that not correct, sir?
That is correct.
Take your time and look.
She,
Yes, sir. And your question again?
The question is, did you look for any of these items?
Yes, in the search warrant we did.
Okay. Now I'm going to show you the third search warrant that you did on December 20th, 2008. May I approach the witness, Your Honor?
You may.
Thank you. Sir, I believe this is still December 11th.
Oh.
December 20th is right behind it, stapled.
Oh, okay.
I could have gone my entire
Did
life.
you, on your
without
search warrant of
another
December
Yuri.
20th, the third time going in there, did you also look again for chloroform items and all of
No,
the
you know.
items that I just finished running down?
No, sir. The scope of the search warrant didn't include anything to do with chloroform or items used to make chloroform.
Okay. And the reason for that would have been?
We already conducted the search for the chloroform products on December 11th.
Okay. And you don't think you would have missed anything on December 11th through when you went back in there on the 20th?
Not to say I wouldn't have missed anything. We just didn't include it in the scope of the December 20th search warrant.
And would that have been because you did such a thorough job on December 11th?
I wouldn't disagree. We had no reason to incorporate it in that December 20th search warrant. We'd already looked for it in December 11th.
Okay. But if you had happened to come across a chemistry kit, you certainly would have confiscated it or photographed it.
We would have done it legally and stopped it and gotten an addendum to the search warrant, yes.
Okay. Did you find any chloroform at any given time in the Anthony home throughout the entire time you've been investigating this case?
No.
I have no further questions. May I get the...
You may retrieve the items. Cross-examination.
Thank you, Your Honor. Good afternoon, Detective Melick.
Good afternoon.
On August 8th, when that search warrant was done at the Anthony residence, you did not have any preliminary or other results from the Oak Ridge National Laboratory regarding high levels of chloroform on carpet samples in the trunk, correct?
That is correct.
Okay. When that information was provided to you and ultimately became public knowledge, that was closer to the end of August, beginning of September of 2008, correct?
Yes.
At that point in time, Ms. Anthony was out of jail and living at home?
I don't recall specifically the date she was in and out of jail, but I would presume so, yes.
Okay. Was she not out of jail between August 22nd and October 14th, 2008?
Yes, I do believe so.
Thank you, Your Honor. I have nothing else.
Okay.
Redirect us to those issues.
When someone is out on bail, that doesn't preclude you from getting a search warrant and searching their home, does it?
I can get a search warrant whenever I believe there's probable cause to have a search warrant issued. So I can get a search warrant anytime as an investigator I would believe it would be necessary. Does that answer your question?
Yes, sir. And you got the preliminary results from the Oak Ridge National Laboratory in late August, did you not?
Yes, that's correct.
And then you got the computer results shortly thereafter.
That's correct.
Okay. Tell the ladies and gentlemen of the jury, after you got that information, how soon you went in to get another search warrant.
After getting that information, the next search warrant would have been on December 11th of 2008.
Okay. So you waited how many months?
From the time in August to December 11th. So it'd be September, October, November, and into December.
And you didn't think that that evidence was significant enough for you to get a search warrant to go look for those items, did you?
Not necessarily. It was obviously very significant, but as to just using that to get a search warrant for the house, no, I did not do that. That's obvious.
Okay. And when you finally did search the home, both times, you never saw anything of the kind.
Now, may I also address your previous question?
Sure.
Also, at the time in August, we were still looking for a live child as well. So even though we had these indications of chloroform in the trunk and in the computer, we were still looking for a live child. So
Good point.
When Casey was first arrested, that was the day after, it was July 16, 2008, right?
correct.
Okay. And then on October 14th, she was then arrested again for more serious charges, correct?
Yes, sir. After October 14th, we were no longer looking.
And you were
for a
no
live
longer on October 14th because you had charged her with murder, looking
Correct.
for a live child, right?
Yes, sir.
Okay. So October 14th, November 14th, December 1st, all those times, you never went in there with a search warrant to look for these items.
I know
Until
how
December
that is.
11th. That's correct.
Okay. No further
That
questions.
on Mondays.
May the detective be excused.
Yes, no request.
Yes, sir.
Okay, thank you, detective.
My excuse or subject?
Ready? Mr. Baez says subject to recall. So you're excused for the day.
Thank you.
You're welcome, sir. The defense may call the next witness.
Yes, sir.
Guys, I don't even
I'm
know.
Marcus Bain Wise, MarcusBainWise.
Good afternoon, sir. Can you see me over there?
Yes, sir.
All right.
Good afternoon.
Can you tell the ladies and gentlemen of the jury what your occupation is?
I am a research scientist at Oak Ridge National Laboratory.
Yep.
My specialty is analytical chemistry.
Executive decision. We are not sharing or doing his thing. Okay.
Good morning. May it please the court, Your Honor?
You may proceed.
Thank you, sir. Good morning, Ms. Montgomery.
Good morning.
Can you please introduce yourself to the ladies and gentlemen of the jury and tell them what your occupation is?
Yes. My name is Madeline Montgomery, and I'm a forensic toxicologist with the FBI laboratory in Quantico, Virginia.
And how long have you been employed by the FBI?
I've been employed by the FBI laboratory for 15 years.
And could you share with us your educational background?
Sure. I have a Bachelor of Science degree in chemistry from the George Washington University, which is in Washington, D.C. I've hosted residue testing to analysis of a sample suspected to be a drug. Forensic toxicology is specifically the study or detection and study of drugs and poisons in people. So I analyze things like blood, urine, hair, and autopsy samples such as liver and brain for the presence of drugs and poisons.
And how are you normally approached to do this? Is it through the FBI or through state agencies or medical examiners' offices? How does the work come to you?
Well, in the work that I do, I would say more than half of the work I do actually supports local and state investigations. We have equipment that not all state and local forensic toxicology labs have. So we have the ability to do more sophisticated testing. So we may get involved for specific requests if a local medical examiner or state forensic lab can't do the analysis. But then we also support FBI investigations all across the U.S.
And have you done any or published any work in the areas of forensic chemistry or toxicology?
Yes, I have.
How many articles or publications have you?
Just guessing, I would say between 10 and 20 peer-reviewed published journal articles.
And do you belong to any professional organizations?
Yes, I am an active member of both the Society of Forensic Toxicologists and the International Association of Forensic Toxicologists. I serve as the secretary of the Young Scientist Committee on the International Association of Forensic Toxicologists, and I serve as the executive secretary on the Scientific Working Group for Forensic Toxicology.
And could you explain to the ladies?
So for our toximum types of quality assurance that are needed in the lab, just to make things equal across the field.
And have you testified as an expert witness in the areas of forensic chemistry and forensic toxicology in the past?
Yes, I have.
How many times and where?
11 times.
And where?
I've testified in.
Refer to your report of March 13th, 2009. Do you recall receiving items of evidence to test?
Yes, I do.
Okay. And what exactly was that, or were those items?
I received a hair sample to test.
And this would be the Q59 hair mass coming from the remains of Kaylee Marie Anthony?
That is correct, yes.
Judge, there's a stipulation between the prosecution and defense that this came from the area of Suburban Drive.
Your Honor, the item is in evidence, so I don't think a stipulation is necessary. The jury heard testimony. If we could just refer to it by its evidence number.
Okay, Madam Clerk, what is the evidence, state's evidence number? Okay. You may continue.
Thank you, Your Honor. Now, ma'am, as it relates to evidence item 271, what instruments do you use to test hair?
Well, as far as biological samples go, hair is actually fairly complex. So the first thing we do in the laboratory is we have to, what we're interested in is any chemicals that might be within the hair itself. And that's because chemicals can be incorporated into our hair as it grows. So we need to get to the inside of the hair. So we will physically break apart the hair, in this case with liquid nitrogen, which makes it very cold and very brittle, so it'll break on impact, and we make it into a dust. Then that dust is extracted overnight in a chemical solvent, so that any drugs or poisons that we're interested in will be leached into that solvent. Then the next day, we do further purification techniques on that solvent and make what we call an extract. And then that extract is taken along with samples of known blank hair and hair that we've added drug or poison to, which are our control samples. Those would all be taken to the instrument that is called a liquid chromatograph mass spectrometer.
Okay. And do you have training on the liquid chromatograph mass spectrometer?
Yes, I do.
Okay. And is your knowledge of utilizing that device extensive?
Yes, it is.
Okay. And tell the ladies and the gentlemen of the jury what you tested for.
In this case, I was initially asked if we could test for alprazolam and clonazepam.
And what
benzos?
Are those?
Alprazolam, you might know, is commonly known as Xanax. That's one of the prescription names. And clonazepam, you might know as Klonopin. They also have other names and can be sold as generics. But they are from a class of drugs called benzodiazepines. They can be used to help someone sleep, to help calm them down. And they can also be used before surgery, again, to help calm someone.
Have you liked my stream yet? Could you please do that? It's free. And while you're at it, if you could subscribe to my channel because it's free, that would be so magnificent. I am almost about to hit another 1,000 subscribers. So I'd love for you to be a part of that. Doing big things over here on this stream. And we're making adjustments daily to fit it all into the greater plan. Thanks, guys.
Down.
Okay. And what were the results for those two drugs?
The testing I did for those drugs was negative in the hair sample.
Now, I know I'm going to butcher the names of these other drugs, but please bear with me. You were also asked to look for a drug, Fluniz. You can help me with the rest.
I can help you. The initial testing that was done was for, as I said, the alprazolam and clonazepam. While this evidence was in the laboratory, we were already validating a new method that included not only alprazolam and clonazepam, but 9 other drugs. And this method was superior to the method we were currently using. So the timing worked out so that while we still had the evidence in the house, I was able to test it again to look again for the alprazolam and the clonazepam, but this time at much lower levels. And then I looked for 9 other drugs as well, which included 8 drugs in the same class as the alprazolam and clonazepam. They're called benzodiazepines. It would include other benzodiazepines such as diazepam, which is Valium, flunitrazepam, which you may have heard of. The media calls it roofies, or the date rape drug. It's one of the drugs associated with sexual assault. and then a series of other benzodiazepines and their metabolites, or the chemicals that our body breaks them down into. And then the last drug that is in the method that I looked for is called ketamine, which is a veterinary tranquilizer that is also abused in the club scene and used for its hallucinogenic properties.
And can you tell the ladies and
Okay,
gentlemen, this is
whoa,
one,
whoa,
two,
whoa,
three,
whoa, whoa,
four,
whoa.
five, six.
Okay, this is outdated. Just so you know, the reason I was dancing for ketamine saved my life. It's also used for treatment resistant, not treatment, medication resistant depression. So ketamine ketamine is incredible. As long as you use it in a, medical facility, you're not doing it like on the street. But I'm a huge proponent of people exploring ketamine and seeing if it's for them, because it was for me and my life is so much better.
6, 7, 8, 9 other drugs. Is that correct?
That's correct. 10 benzodiazepines plus ketamine.
Okay. And can you tell the ladies and gentlemen of the jury what the results were when you searched for those drugs?
My results were all negative.
And can you explain, you mentioned that you had a new technique that was even more sensitive than the one you had previously had. Is that correct?
That's correct.
How much more?
On the order of about 10 or so.
Okay. 10 times more?
10 times more sensitive, yes.
Okay. And were there any other drugs that you tested for?
No.
Okay. And as far as this report is concerned, were you able to, I just want to double check, make sure. As far as this report is concerned, did you test any other items?
No, I did not.
Okay. Now, you can't testify as to anything outside of the results of the tests you did. Is that correct?
That's correct.
And you can't guess how much use would be required before these drugs would show up in the hair, can you?
Objection leading.
Sustain, rephrase the question.
You don't know how much exposure a person would have before these results show up, do you?
Objection leading.
Overruled.
The thing about hair testing after limited exposure is that even in controlled studies where someone is given a known amount of a specific drug and then their hair is tested, we're not always able to detect the drug in the hair. So the answer is, I don't know. There is no, certainty with how much drug someone needs to be given or needs to take before it will show up as positive in their hair.
And you can't speculate as to whether it's 1 time or 20 times before it actually shows up, right?
No, I cannot.
All you can say is, we do these highly sensitive tests and they're either positive or they're negative.
Objection leading.
Sustain.
All you can say, well, let me rephrase that. Is all you can say that you did these tests and they came back negative?
That is correct.
I have no further questions, Judge.
Cross-examination.
Good morning.
Good morning.
So in summary, the negative result is forensically meaningless. It doesn't mean the person wasn't given the drug. It doesn't mean they were. It just doesn't mean anything.
It means that I did not find any evidence of the drug having been given, correct?
But it still could have been given and not shown up in the hair.
That is correct. Hair is not the best sample for drug exposure.
So in determining whether someone has been given a drug or not, a negative result really doesn't answer that question.
No, it does not.
And even if it did answer the question, it only tells you historic use of drugs. It doesn't give you chronic use of drugs.
Well, it depends on how the testing is done. If you were to test someone like me with long hair, I could look at the length of the hair to look at different time periods of exposure, and that would indicate if I was positive down the entire length of my hair that I was a chronic user of a certain drug. But in this case, the hair was such that we had to look at it in bulk, meaning we had to look at it as one sample. So even had it been positive, I wouldn't be able to say when or how often the person was exposed.
And if someone were exposed to something and died immediately or very closely, it wouldn't appear in the hair anyway.
That is correct.
And you're not able to test for chloroform, are you?
Not in hair samples, no.
Is there anything about your findings that would have indicated that this child drowned?
I have no expertise in that area.
Nothing further.
Redirect.
Ms. Montgomery, what other kind of meaningless work do you do at the FBI?
I don't feel that any of my work is meaningless.
Okay. And
What?
the chloroform that you test, the reason you didn't test for chloroform is that study, that type of analysis is not done by your lab, correct?
We don't look for chloroform in hair samples. We will look for chloroform in liquid biological samples, but not in hair.
And
Anyone
and
having
you were
an
made aware that
inhaler?
Dr. Goldberger was the one that was doing that, correct?
Hearsay.
Judge,
Sustain.
do you have knowledge as to whether that was done by another scientist?
Objection. Hearsay.
Sustain.
Your Honor, this is an expert witness who is
Sustain.
now. The reason, obviously, you testified that certainly your work is not meaningless. The reason that you do tests is to search for evidence, correct?
We do tests to answer questions, yes.
Yes. And in this case, you had a sample, you did the test, and the results came back negative.
That is correct.
No further questions.
Okay, may the witness be excused.
As far as the state's concerned, yes, sir.
Thank you, ma'am. You may be excused.
Thank you.
Thing did you do then?
We proceeded to Orange County Sheriff's Office.
Stop a second. You said we.
Doug Clark and myself. Doug Clark is an associate who works in the laboratory with me. So we proceeded to Orange County. We took with us 2 Tedlar bags,
I can take these
a
off.
gas-tight
I
syringe.
always forget about that. Sorry, guys.
Michael Rickenbach, Rickenbach.
Sir, what is your position again? What is your position and your occupation?
I am a forensic chemist examiner within the laboratory division of the Federal Bureau of Investigation.
Your Honor, we would reassert that Michael Rickenbach has been previously designated as an expert witness in the area of forensic chemistry.
That's correct. He has.
Ladies and gentlemen, the certification still stands. You may continue.
Let's give him a shot.
Sir, I'd like to direct you to your a report you did in this case dated July 6th of 2009. Do you have that with you?
Do you have a copy or?
Yes, I have a copy I can give you.
It was useless. He said useless because the prosecutor, it literally insinuated that the woman's work in that field was useless. Like it had no meaning. And so the defense attorney went up there and was like, what other useless work do you do? It's caught me very off guard because I'm trying to type these messages to you guys.
May I approach the witness?
You may.
Before counsel, could I take a look at my copy of it?
After you've had a chance to review it, sir, let me know.
I'm ready.
Were you given certain items of evidence to inspect and do tests on, sir?
Yes, I was.
Okay, and what were those items?
These items we designated with certain Q numbers. They were a bottle, liquid within that bottle, a syringe with a needle on it, and liquid within that syringe. There was an unknown substance within a bottle.
Objection. Objection. Reference to items are not.
I can't hear you.
I'm sorry. Objection. I object to testimony about things that are not in evidence. Those items are not in evidence. We can approach them.
No. Are they in evidence, Mr. Baez?
Well, they're in the possession of the sheriff's
No,
department.
no. Are they
May we
in
approach,
evidence?
Judge? I'd like
If
to.
they're not in evidence, objection sustained, but you can approach.
Dr. Rickenbach, I'd like
Just a
to.
second.
I apologize.
You may proceed.
Dr. Rickenbach, I'd like to direct your attention to the report that you issued on December 11th of 2008. Do you have that with you, sir?
If you'd have a copy.
Sure. Did you receive certain items from the Orange County Sheriff's Department?
I received items from my evidence control unit, which in turn received them from the law enforcement agency. Yes.
Apparently, I'm stopping my stream if I don't get more likes. So if you are enjoying yourself, please make sure to like my stream because you guys are upsetting my mods. So please make sure to like my stream. Thank you.
And could you tell the ladies and gentlemen of the jury what those 2 items were for that report?
The items related to this report were one car seat. We designated as item Q47 and an item reported as being a steering wheel cover, item Q48, according to this laboratory report.
And Your Honor, I believe by previous stipulation, these 2 items were retrieved from the Pontiac Sunfire from with the tag number. Is the tag number on your report?
There is no information about a tag number on this report.
The Pontiac's on fire that belonged to Miss Anthony.
What says the state?
Your Honor, we're just looking, we think that the steering wheel cover may actually.
You have to turn your microphone on.
We don't have an objection to proceeding with that stipulation. We're going to check. We think that the steering wheel cover may actually be marked, and the defense can move that into evidence, but we're going to check and see if we did have that marked.
Peggy,
You may continue, Mr. Bias.
And what were you asked to test these items for, sir?
let's have maybe.
I was asked to test
Answer
for the
that.
presence of
Or
volatile
lefty.
substances, particularly chloroform.
Okay.
I don't know if
And
Bubs is
can you
still-
tell the ladies and gentlemen of the jury what your results were?
That chloroform was not identified on either one of those pieces of items.
And why would you test the steering wheel cover? What's the purpose of that?
I'm not sure why it was requested. It was just when the items come in with a certain request from a contributor, we perform those tests.
Okay. Were you informed at any time that the purpose was to see if chloroform had been on someone's hands?
Objection.
That drove,
Hearsay.
may I finish the question? Chloroform that might have been on someone's hands would then possibly transfer to the steering wheel cover?
Objection, hearsay, and relevance.
Mr. Ashton?
Objection, hearsay, and relevance.
It would go to, Your Honor, would go to his items that might contribute to his opinion.
Sustain.
And the other item that you tested was exactly what again, sir?
Besides the steering wheel
Yes,
cover was
besides.
Q47, which is a car seat.
The child's car seat?
Yes.
And you found no chloroform on that?
Chloroform was not identified on that item. No.
Now, I'd like to direct you back to your previous report on July
Yeah.
609.
I'm sorry, may I clarify? Chloroform was not identified on the samples that I took off of that item. I cannot say for sure that I did not analyze the entire car seat. I took cuttings that were representative of that car seat that I thought, and no chloroform was identified on those cuttings.
Understood.
Want to clarify that, please?
Understood.
Oh,
And were you also given another item to inspect for chloroform? I believe that's noted on your report of July of 09.
The original report.
Correct. The first report I showed you. I'm going to. What were you given, sir? To inspect?
According to this report on July 6th,
Yes.
you want me to list all the items?
No, just the specific. If I can look at your report again, I can give you the Q number. So we don't.
You have a request if the item is marked, it be put into evidence prior to testimony about it.
Well, he can list what he's looked at, but he can't test it. He can talk about what he's seen, but he can't talk about any results until they go in the evidence.
Ha ha ha, Lefty, you're so funny.
You may.
Judge, at this time, I would move HR states to HR evidence.
Was it marked for identification by the state, but not entered by the state?
Yes.
Yes, sir.
It be received in evidence as defense numbered.
Without objection.
Sir, were you given a doll to also check for chloroform?
Yes, a doll was submitted for analysis.
And did you conduct the examination on the doll to see if that had the chloroform on it? And can you tell the ladies and gentlemen of the jury what those results were?
I did receive a doll for the determination if chloroform volatile chemical was present on that item. I took the sampling of that item, and the analysis of the samplings, chloroform was not identified.
I guess
I have
Lefty's
no further questions
misbehaving.
for Dr. Rickenback at this time.
Cross-examination.
As to the examination of the doll, was there not an early indication of the presence of chloroform that you had to go and get another doll to check? Am I remembering the right item?
When analyzing the doll, there were indications of that chloroform may be present, but in very, very small amounts. I requested that a similar doll be submitted. That was not available. A coworker submitted a doll that she had. I analyzed that. Again, very small amounts of chloroform, related product, and so it just was not enough for me to render a decision that chloroform was identified on that item.
So there was an indication of chloroform, but you
Object about on this and request a sidebar.
You may. You may continue.
okay? If you would go ahead and finish your answer about your exploration of chloroform issue on the doll.
what is commonly done is that a negative control is usually run with the same sample matrix. So in this case, it was the fabric or the stuffing of the doll. Because I got indications of possible chloroform, whether it be from the chloroform or from the material during the process of examination producing chloroform, I wanted to get a negative control doll to say if the chloroform maybe just would come from the material itself. And I got the control doll, and it gave very, very low indications of possibly chloroform. So that with the very low amounts within the initial specimen, I was not comfortable in saying chloroform was identified in that item.
So you were able to obtain a doll, but not one of the same make and models for doll, but the same make and manufacturer. You weren't able to get one identical, but you got one that seemed similar. And since it had chloroform, you were not comfortable in saying that the chloroform in the doll wasn't just from its manufacturer.
He's correct in saying that I did not have a doll of the same type, but it's not that the doll had chloroform that I couldn't rule it out. It's just there was small amounts, and it was just too small for me to comfortably say that it could be identified as being a contaminant within the doll.
All right. Thank you very much. That's the only question I had.
Redirect.
So just so we're clear, sir, a coworker of yours has a child that her doll has chloroform on.
No, that's not what I said at all.
Okay. You found another doll that had chloroform on it. Is that correct?
No, that's incorrect. I did not have the data enough to say that chloroform could be identified on either one of those items.
Okay. And that's because chloroform is found in many products.
I'm not sure where the chloroform came from. Chloroform is in other products. Whether the chloroform is in this product, I don't believe so. It may be because it uses heat and that the technique, chloroform may have been produced from the material. That's why we use a negative control so that we don't falsely or incorrectly identify something that shouldn't be there.
And chloroform can be found in water as well?
If it's present in high enough amounts for us to detect and identify, yes.
I have no further questions.
Recross?
Could we approach quickly? We have a resolution on it.
You may continue.
Yes, sir. Dr. Rickenbach, you also, I'd like to refer you to your report back in July dealing with the Gatorade bottle and the substance that was inside of it. Do you recall those items?
Yes, I do.
Okay. And what were you asked to do in that report?
In the Gatorade bottle that was submitted, there was an unknown liquid within that bottle. Also, there was a syringe with a needle, and there was liquid within that syringe. I was asked to identify or try to identify what the liquid and the two liquids were.
Your Honor, may I publish State and Defense 32 for the jury?
You offered that provisionally
Yes, sir.
in the objections from the state?
I believe the photograph is already in evidence.
Oh, it's
Without
in
objection.
evidence?
Yes.
The photograph is, yes.
Well, go ahead.
Yes.
You may. What's the exhibit number?
32.
You may.
Can you? Thank you, sir.
This is not upset. This is laughing.
Is this, sir, the Gatorade bottle that you tested? Or does it appear to be?
It appears to be the Gatorade bottle that the liquid was within.
Okay. And what was inside of it?
You want the results of my report?
Yes. Tell the ladies and gentlemen what you tested
This
and what the
is
results
first
of your
time hearing
report.
about this
Okay,
bottle.
just for accuracy, could I get the report back?
I thought I gave it to you. Sorry. Go ahead and tell the jury what you found.
The liquid within the Gatorade bottle was a whitish, murky kind of liquid. While it was not fully identified, it could have come from some kind of type of cleaning product or cleaning product added to it. Additionally, a mixture of testosterone compounds were identified within that matrix.
And
Was
did you
it
find a syringe
For
as well?
dads?
There was a syringe with a needle on it within that bottle, yes.
And did you believe the syringe to contain, or did you find the syringe to contain testosterone?
There were within the liquid of the syringe was an oily kind of liquid, yellowish oily liquid, and within that same testosterone compounds were identified.
Okay. Now, in this liquidy substance, what instrument did you use to detect these items?
The testosterone compounds.
Yes.
There was a technique called gas chromatography, mass spectrometry,
I'm not
and,
going to be reading the chat because
time of flight mass spectrometry, which was used to identify those compounds.
And in this liquid, did you also detect very low levels of chloroform as well?
Within the Gatorade bottle liquid, the one that could have come from some type of cleaning material, low amounts of chloroform were possibly present, but they were very small amounts.
And the reason you did not report those out is because, of course, they were at such low levels and because they could have come from the cleaning product.
This is correct.
Your Honor, at this time, we would provisionally move to enter into evidence the items discussed and testified to by Dr. Rickenbach, which are specifically.
I don't believe the items are here yet. I believe the agreement was the testimony was provisional upon the items being placed into evidence at some future point.
Okay.
I do agree with that.
All right.
I have no further questions for Dr. Rickenbach at this time.
Okay. Cross-examination on those issues.
The amounts of
Yeah, I
You did not
mean,
report out the chloroform in your report, correct?
that's been going
Just
on
like with the doll,
forever.
it was such a small, minor amount that was attributable to cleaning products. You didn't even report it out.
This is for Peggy.
That is one of the reasons. The other reason was it was more of what compound, what are these, more of an identification, not just specifically for chloroform. And that
'Cause
the
I
request
can't
was more
say
for
it.
identification of what this compound was.
Where your
But a lot
identification
of-
as a cleaning product, was that based upon the mass spectra other than just chloroform, all the elements taken together?
Yes, there were indications that this was a cleaning product, and chloroform has been known to be in cleaning products, so it was not of any really surprise.
So the GC mass spec would give you a total spectrum that would convince you it was just a cleaning product.
The instrument can't identify a cleaning product. It just, based on my examination, the smell of it and the products that potentially came out, it was a possibility that it could have been a cleaning product added or from a cleaning product.
No further questions.
May the doctor be excused.
Yes, sir.
Thank you, doctor. You may be excused.
My name is Karen Korsberg Lowe. Korsberg is Korsberg. Lowe is Lowe.
Good morning, Ms. Lowe.
Good morning.
Your Honor, I would ask to recertify Ms. Lowe as an expert in hair and fiber analysis.
Ladies and gentlemen of the jury, Ms. Lowe has been previously recognized by this court to be an expert in hair and fiber analysis. You may continue.
Thank you, Your Honor. Ms. Lowe, I wanted to go over some of the reports that you didn't have the opportunity to testify about last time.
Okay.
Let's start with August 13th of 2008.
Give me the FBI lab number so both the witness and I can pull out the correct report.
Okay.
Sure.
Nope.
I'm sorry, could you repeat the date?
Yes. August 13th, 2008, lab number 0808 1105 and 6. Yes. Yes.
Guys, I'm finding the next stream. That's why I haven't been as engaged with the chat. I'm like going back and forth.
Do you have
on
that report, ma'am?
who I want to show. Definitely not him.
Okay.
Super
And
boring.
describe that for me if you would.
The conditions of the
Whatever I make them to be, I had to be
Let's
there
do this.
at least from 8:30 to 5.
And with 1.5 times
Cynthia
speed.
Anthony, CYNTHIA, Anthony, ANTHONY.
You may proceed.
Thank you, Your Honor. Good afternoon, Mrs. Anthony.
Good afternoon.
Ma'am, you also lived on, let me rephrase that. You used the computer at your home, correct?
Which one?
The desktop computer.
Yes.
And that is, where's the desktop computer located?
It's now our spare room. It used to be Lee's bedroom.
Actually,
And the,
guys, let's go ahead and end there. And we'll start here on Tuesday. Starting with Cindy is, I think, a good plan. So thank you, everyone. To my mods, you guys are just my freaking, you rock my world. And to my haters, I love you because you guys are here helping the algorithm. And I mean, I couldn't ask for better support than that. I am trying to make it so that I can redo direct y'all after this stream. Pardon me. If you guys just hang in here one moment with me and talk amongst yourselves. What are you guys doing this weekend? Did you guys create any New Year's resolutions? Kind of interested in that. Let me know. All right. Saved the redirect. Now the next one. You guys will like this. I think I'm dropping by this, the place that I'm sending you guys to. I will be more than likely dropping by as a guest this evening. So I hope that you enjoy this. And there you go. If you haven't done so already, please make sure to like and subscribe. And I will be here on Tuesday at 3:30. And we will start off with Cindy's testimony. So I appreciate everyone for being here. We're so close to these huge accomplishments with this channel, you guys. So keep it up. I appreciate everything. If you want to share the stream, that helps even more. So thank you. Have a lovely evening, weekend, Monday, all the things. And I will see you on Tuesday.